3 hours?
I think 3 hours would be okay, but in the event that I need 30 more minutes, I hope you'll be flexible enough to accommodate me in that respect. Mr. Stagi will deal with just one aspect of the heads of arguments, which is the last part, which is the D part, dealing with inadmissible evidence. So between Mr. Stagi and myself, 3 hours is fair.
Even if you need less time, I'll accommodate you on that.
Yes, no, I certainly would be. I would appreciate that, but it's most likely more time than less time.
No, that's fine. And the JSC, we also think that the 3 hours would be sufficient. Mr. Maleka? Advocate Maleka SC? Or Mr. Mandlakayise, maybe you can respond on his behalf. I don't see him on the screen.
There, Mr. Judge.
Okay. Yeah.
As between myself and Mr. Mandlakayise, 3 hours will be enough. We might even need less.
Okay.
Can I indicate that we have divided the argument between ourselves, and Mr. Mandlakayise will deal with that part of the attack directed to the composition of the JSC at the relevant meeting, and I'll deal with the rest of the attacks.
Okay, thank you. Then the speaker, Mr. Patlenda, you looked at your heads. Will 30 minutes be enough, or do you think you'd need more?
No, Judge President, Deputy Judge President, I think 30 minutes will be sufficient. I do have one slight difficulty, unfortunately, which is that I have a pre-existing appearance in the Con Court tomorrow. And so I'd be greatly appreciative if I could be accommodated either today or on Wednesday, whichever is easier for the bench. But 30 minutes will be sufficient. Thank you.
Okay. Yeah, I think we will deal with that. And for the justices of the SCA, Advocate Gilbert Marcus, we're thinking that an hour would be enough, or would it need more?
My Lord, I think an hour and a half will do it.
Okay, we will give you an hour and a half.
Thank you.
Fine. Full Advocate Duplessis, we are estimating about an hour. Is it sufficient?
An hour will be sufficient. Thank you, DJP.
Thank you. And then the amicus for the BLA, we also think that 30 minutes to 1 hour will be enough.
Thank you.
Donnie?
Thank you very much.
Will that be sufficient?
Good, thank you.
Okay. Yeah, then I think then we're ready to proceed. Yeah.
My Lord, may I just raise one issue of procedure? We're obviously entirely in your hands, but it would seem to us to make sense for the BLA to follow the judge president, because those two parties are essentially advancing similar arguments. That is my only suggestion.
Okay, so the sequence that you're suggesting is that after argument, Advocate Masuku, the BLA to come in. And regarding the other parties? No, you don't have any.
Subject to Mr. Badlander's difficulties, we're more than happy to do it in the order as they appear, on the papers. In other words, the JSC followed by the Constitutional Court Justices, followed by freedom under law.
So Mr. Batlender can come in after the BLA.
Yes.
Yeah. Okay, thank you. DJB Sutherland, do you have any comment?
Nothing to say at this stage, DJP. We do need to deal with the formal admission of the amicus, though.
Okay. And Judge Victor?
DJP, I'm in agreement with the procedure as outlined now.
Okay. Yeah, now as DJP Sutherland has indicated that
to the misconduct complaint and essentially an endorsement of a biased tribunal report and a failure just to apply the law as we understand the law in these kind of matters. This part B deals essentially with the jurisdictional issues. Those issues relate to whether the JSC was properly constituted, who should have been in the JSC, who shouldn't have been in the JSC, and whether the tribunal itself was worked within its statutory mandate, and if it didn't, then we contend that its report cannot survive if the together with the JSC report. And then part C, we deal with we deal with the issue relating to part C, we deal with the issue relating to whether the relief in paragraph 10 of our notice of motion, and that is in the event the matter is referred to Parliament, and it has already been referred to Parliament. But our concern is that Parliament's conduct when that matter is brought before them is the subject of our paragraph 10. And then our part D deals with the admissibility of the JSC's own evidence in this particular application. I intend to follow a sequence that's slightly different to that followed in our heads. And so I start with the composition complaint, which would have been our part B. But perhaps before I do so, let me say, let me make the following remarks. A complaint, or rather a finding that a judge, later on a judge president, has been found guilty of gross judicial misconduct, has to be one of the most difficult and perhaps a serious finding. And it rightly evokes public outrage or public interest. And that's simply because of the nature of judges, the nature of the office of judges. The society attributes honor, wisdom, detachment, probity, prestige, and power to the office of judges. And so where a judge has been found to have been guilty of gross judicial misconduct, essentially what that means is that to that particular judge cannot be extended the presumptions that are readily extended to judges. One of which, the most important, which we contend the JSC failed to apply, is the presumption of judicial integrity. Society presumes that judges have integrity. Society and judges presumed as against each other extends that presumption to each other. And that is part and parcel of what we regard as a judicial independence. Without those presumptions, judges are certainly vulnerable to abuse, they're vulnerable to attacks, they're vulnerable in their exercise of their judicial functions. So we certainly are quite concerned that in the JSC there are two. There's been Justice Hlophe, I'm not sure that you gave a directive that people should not, those that are not arguing, they shouldn't show themselves on the screen. I'm not sure. There is a Petro van Wyk who is showing a face, and there's another face which I'm not sure. It looks like it's not Ngwaitobe, I can see that, but it is Ngwaitobe's face. And I think it's Hlophe who is my, yeah.
I did not give any.
Okay, thanks.
Thanks,
JP.
Of Judge Sutherland would be in control of.
I can't hear that. I can't hear that, JP.
No, I'm saying I haven't given specific.
There's a break in the.
Can you hear me now?
I didn't hear what you said.
I did not give any specific.
Yeah, I can hear you
regarding who would be appearing here. However, I take it that the secretary of DJP Sutherland would also be in control of that aspect. I did see a face there. However, I would prefer that maybe for now, the faces that should appear should be of the counsel who are arguing the matter.
Yeah.
You can continue.
Thank you, JP. I mean, I therefore just the remarks that I've just made regarding the nature of the judicial office and the presumptions that are extended to them. And we will submit, when we deal with part A of our submissions, that the JSC simply failed to apply the correct law when they determined whether or not the tribunal report should be admitted. And honorable justices, the second proposition I wish to make is an uncontroversial one. A finding by the JSC must reflect the correct law And where the JSC has not complied with the law, it must be reviewed and set aside. It must comply with the law both procedurally and substantively. And so it's uncontroversial that there is currently no unanimous view which assists the public understand the specific factors that ought to be taken into account when adjudicating a complaint of gross judicial misconduct. We submit that there was a failure of constitutional leadership by the JSC to provide a clear guideline that would assist both judges and society at large in determining when it is appropriate to withdraw the presumption of judicial integrity to a judge who is faced with a complaint of the nature that Judge President Hlophe was faced with. When is it appropriate to withdraw that presumption? And here you would have seen that the presumption obviously applies to both judges to all the judges who were involved. And the presumption would simply say, it's summarized more crisply, perhaps, it's to simply answer the question, should it be readily assumed that a judge who makes remarks about a pending matter intends to influence other judges who are listening, given the presumption of independence that is presumed in relation to those judges and the judge making the remark, given the oath of office that judges take and the knowledge of judicial practice readily available to the complainants and to society in general? Should the presumption of judicial integrity be readily withdrawn on the basis that a comment or a remark on a pending matter was intended to influence a judge? Let me start where I said I would start, and that is to start at the composition of the JSC, because that is a jurisdictional requirement. It is a requirement without which the JSC finding is reviewed and set aside, would be a nullity. And in that respect, I intend to rely on two judgments. The judgment in the Judicial Services Commission versus the Cape Bar Council, and the Hlophe versus the Premier of the Western Cape judgment. Both judgments are binding on this court insofar as they give a definitive interpretation of what constitutes a proper composition of the JSC that decides or a question of gross judicial misconduct. They give a clear and unequivocal interpretation of Section 178 of the Constitution, particularly in relation to those questions relating to who should be in the JSC and who shouldn't be in the JSC. Just so it's very blunt and straightforward, Justice Mba, who was part of the JSC, has simply no constitutional status to have been in the JSC. That's as simple as that. And it's as simple as that because he is neither the JP, his position is not referred to anywhere in Section 178 of the Constitution. He is not the Chief Justice. He is not the President of the Supreme Court of Appeal, certainly not the Judge President. We know he is a judge of the Supreme Court of Appeal. So we submit that his involvement in the JSC was not authorized at all by the Constitution itself. And so his involvement in the JSC renders the JSC findings unlawful to the extent that a member who was not supposed to be a participant in those processes participated, gave input. In fact, his role appears to have been quite decisive in how the majority tend. They and the first proposition is that Justice Mba has no constitutional status because it doesn't feature anywhere in Section 178. The second one relates to the fact that Justice Mba was in fact a panel member of a decision of the Constitutional Court in Kabinde versus the Judicial Services Commission, where the Constitutional Court judges refused to hear and entertain a constitutional issue raised by Justice Kabinde and Justice Jafta relating to the conduct of the JSC's issues. The JSC essentially found, the Constitutional Court essentially found that none of the justices who appeared there in that panel could in fact deal with the merits of that particular application, because it held that almost all of them were conflicted in some degree to be part of an inquiry into the merits of the application. Having excluded himself from that panel on the basis that there was conflict, we submit that it would be improper for him to then appear in the JSC to deal with the merits of the JSC application, because the same matters, the same questions that were raised, essentially the same questions, not in the sense of trying to inquire into whether or not Judge President Hlophe attempted to influence Judge President Jafta and Kabinde, but in the sense that the applicants in the Kabinde and versus the JSC case were seeking to overturn the process of the JSC on one or other ground, which is set out in that particular judgment. And the court, they said, no, they can't hear the matter because it implicates the members of the bench in that scenario. So we would submit that Judge Mba, for the second, on that basis, that he was part and parcel of a panel of the Constitutional Court members who decided that they would not hear a legitimate constitutional complaint by Justice Jafta and Kabinde, could not then sit to decide the question. The arguments against that particular the involvement of Justice Mba are two, as we understand it, there are three. The first is that Justice Mba was lawfully delegated to appear in the JSC by the Supreme Court of Appeal President and the Deputy President of that court. Well, the problem with that is that, firstly, there is no law that allows the President of the Supreme Court of Appeal or the Deputy President of the Supreme Court of Appeal to delegate that position to a member of the court. There is simply none. It's not one of those. In the Constitution, you would have seen that some of the members have alternates. The judge, for example, there are a number of members of the JSC who have the Constitution says they can appear alternatively an alternate, and the Supreme Court of Appeal justices of the Supreme Court of Appeal President simply doesn't have the alternate and it couldn't lawfully delegate that position to the President. And this also dovetails to and let me develop that argument a little further, because it penetrates the first basis on which we contend that Justice Kampempe then was also it was also unlawful for her to appear, or improper for her to appear before the JSC as a chairperson. We say so because sorry, let me just walk backwards and deal and finish my argument with relating to Justice Mba. I apologize for that. Relating to Justice Mba. So with Justice Mba, we've submitted the three grounds on which the content is authorized to sit. They say, firstly, our opponents say, firstly, he was delegated. There is no delegation. They are not able to show us any law that allows the president or the deputy president to delegate such a power or such a role to any judge of the Supreme Court of Appeal. There's also no evidence of that delegation, if in fact it was permitted. The confirmatory affidavit issued of President Maya does not confirm the allegation of delegation. One can look at that confirmatory affidavit. It does not confirm in very clear and certain terms that she believed that she had the authority to delegate her constitutional function to Justice Mba. And then the second one is that Judge Mba is a head of court. Well, that doesn't make any sense at all, because it doesn't answer the question that we meant to answer. What is the status of Judge Mba? If he's a head of court elsewhere, he's not. That doesn't give him the status of the president of the Supreme Court of Appeal. And so that argument essentially should be an argument that takes the matter nowhere. So we say, and then there's really just no basis on which Justice Mba's involvement in the JSC can be saved. And these attempts to try and present legal arguments that are incoherent is just that. They don't make sense. Are not consistent with what the cases that have dealt with the composition of the JSC say, particularly on the involvement of the president of the Supreme Court of Appeal. You'd have seen that the JSC versus the Cape Bar Council dealt exclusively with the fact that the president of the Supreme Court of Appeal was absent, and that was found to have been a basis on which to set aside the JSC decision in the appointment of judges here in the Western Cape. Then
Advocate Suku, if maybe I agree with the point that you are raising, that Justice Mba was not supposed to be there, what remedy do you think would be appropriate for the matter to be referred back to the JSC to reconsider the recommendations of the tribunal, or what do you think would be the appropriate remedy?
Justice, Deputy Judge President, the first thing would be to set aside the JSC finding, and perhaps under your powers under Section 172(1)(b to look for a just and equitable order, would decide what you do in the event you set aside the JSC finding. We submit that there are considerable problems with considering a remittal to the JSC as a just and equitable order. And it's for the reasons that if you set aside this decision, which you should, this would be the second time that a JSC finding is set aside on a similar point involving composition. Simply put, the JSC has failed to exercise its constitutional obligations. We would submit that referring the matter back to the JSC may well be an option available, but there are considerable problems with that kind of order, because of the fact that the JSC, if one looks at how the JSC has responded to this application, it's inconceivable that anybody would believe that the JSC, having taken the position they've taken in this particular application, would exercise their minds differently if the matter were referred back to the JSC. But can I deal with the issue of remedies when I get to that particular point? But we submit that on the authority of the Supreme Court of Appeal judgments, the two judgments I'm relying on, the JSC the Hlophe versus the Premier of the Western Cape Supreme Court of Appeal judgment, and the JSC versus the Cape Bar Council judgment. On those two judgments, it's clear that you must set aside the judgment. I'm sorry, the findings of the JSC on the issue of composition, and what the JSC does with it is a matter for the JSC to decide later when the matter is remitted back to them. But as we say, we want to make it clear that the JSC is no longer a dependable constitutional institution in relation to this particular matter, to provide the kind of leadership that it must provide in order to ensure that judges who appear before it, charged with serious offenses or serious complaints of judicial misconduct, receive a lawful attention. And Judge President Hlophe, if you recall, has set aside the JSC's actions in 2008, when all the judges of the Constitutional Court had testified in his absence. That whole process was set aside because the JSC was simply doing something that was unlawful. In 2009, the JSC found in favor of Hlophe, set aside found that there was no judicial misconduct or gross judicial misconduct. That favorable outcome of the 2009 JSC finding was also set aside on a number of bases. The first being that the JSC was not properly constituted, the Premier was unavailable, or was not present as a panel member, and that there had been no cross-examination conducted to reach the decision that the JSC had reached. And then, of course, we now have a situation, we're back exactly there, where the JSC, 13 years down the line, the JSC still can't get it right. So this court would be correct to issue a declaratory order in the terms we seek in our notice of motion. Make it clear that judges who face judicial misconduct carry the hopes and the dreams of people who appear before judges, who presume that judges have integrity, presume that judges are independent. The confidence in the judiciary is constantly eroded when the JSC simply fails to perform its constitutional duties. And in this case, it's clear again that they did not perform their duties with the diligence that the Constitution requires them to perform those particular duties. So we would say that if you find in favor of the applicant on any of the jurisdictional attacks, then of course the matter you must declare that the findings of the JSC should be set aside as a nullity, and the JSC must just do its job properly.
Mr. Masuku, can I ask a question at this time?
Yes, Judge Sutherland.
Your proposition is that Judge Mba was not lawfully present. Now, if we take as a point of departure that both the President and the Deputy President of the Supreme Court of Appeal were absent for legitimate reasons, what is supposed to happen when that occurs?
Thank you, Deputy Judge President Sutherland. That question is answered by reference to two provisions, Section 1787 of the Constitution, which says that if the Chief Justice or the President of the Supreme Court of Appeal is temporarily unavailable to serve on the commission, the Deputy Chief Justice or the Deputy President of the Supreme Court of Appeal, as the case may be, acts as his alternate. Now the question is, what happens when both of them are unavailable? And the answer is appears in Section 2 of the JSC Act. Section 2.2 of the JSC Act it regulates the chairpersonship of the JSC. It says when the chairperson, and the chairperson, you would have seen, Justice Sutherland, that it means the Chief Justice. So when the Chief Justice is for any reason unavailable to serve on the commission or perform any functions or exercise any power, the Deputy Chief Justice as his or her alternate shall act as chairperson. If neither the Chief Justice nor the Deputy Chief Justice is unavailable to preside at a meeting of the commission, the members present at the meeting must designate one of the members holding office in terms of Section 178(1)(b) and C of the Constitution as acting chairperson for the duration of the absence. Now, if you go to the Constitution to look at 178(1)(b), it's a reference to the President of the Supreme Court of Appeal, or the C, the one judge president designated by judge presidents. In this case, if the Constitution envisages that where the deputy president, so where the president and the deputy president are unavailable, then of course it would have been just Judge President Mlambo who would have chaired the commission. That also presents difficulties, Justice Sutherland, because of the judgments I'm going to refer to, the two judgments of the Supreme Court of Appeal.
Before we get there, perhaps you're not quite answering the question that I posed. Let's park the question of who should chair. If we look at section 178(1)(b, and we read that with section 2 of the JSC Act, if, as it said in the papers, both the president and the deputy president recused themselves because of a potential conflict of interest, there's only one of two possibilities that must then happen. Is either they are simply not members of that particular meeting of the JSC, or they can be substituted. Now, is it possible to substitute them?
No, it is not possible in terms of reading both the Constitution and the Act together with the judgments of the SCA on that particular question. In fact, that issue engaged the SCA in the JSC versus Cape Bar Council, and the court said the court basically said it's not even thinkable that a member who is mentioned in that particular in the Constitution would simply be unavailable to serve in that position. But we do not have authority that suggests that the absence of the Chief Justice or the Deputy Chief Justice or the President or the Deputy President can simply be substituted by any member. We do not have an authority in terms of which we can say, well, this is what happens. We know what happens when the Chief Justice is not there and the Deputy Chief Justice is there. We know what happens if the President is not there, and the Deputy President is there. But the Act and the Constitution does not tell us what happens if both of them are not there. And the Supreme Court of Appeal has made it clear that it should not be a light moment for a JSC for a JSC member who is mentioned in those particular provisions of the Constitution to simply be unavailable. And here I can get to that question of unavailability, where the unavailability is based on the fact that there is a conflict of interest that both President and the Deputy President suggested they suffered from, and we can make submissions to the effect that did not mean that they were absent, in the words of the Constitution as interpreted by the Constitutional Court judgment in Hlophe versus the JSC, the matter in which Judge President Hlophe couldn't get a hearing in the Constitutional Court because the Constitutional Court took the view that they didn't have the members of the Constitutional Court were conflicted. So they cannot be pragmatism, and the Supreme Court of Appeal makes it very clear that pragmatism and good sense will not work. And to look for a substitution where the law doesn't allow for a substitution would be to act pragmatically. But we submit that JSC ought to be absolutely rigorous in its lawful application of the Constitution, and there is no room for the JSC to simply say that in the absence of a member, they can simply get somebody else to come and sit in the place of that particular individual. That is a matter regulated by law, and we submit that the law doesn't provide for a substitution in the event both President and Deputy President are unavailable.
Thank you.
Let me address then the question involving the Justice Kampempe. The first proposition the first submission I make is that Justice, Acting Deputy Chief Justice Kampempe was appointed by the President on the recommendation of the Minister and the Acting Chief Justice to preside over the JSC meeting. There is simply no constitutional basis for that appointment, because there is no power of the President to appoint a member of the judiciary for the purpose of performing a JSC function. You will have seen in the papers of the JSC that they make it abundantly clear, together with the letter of the Chief Justice and that of the Minister, that the appointment they seek from the President is the appointment to a position, but for the sole purpose of performing a JSC function. And we submit that the law doesn't allow the President to make acting appointments in order to fill vacancies in the JSC forum, and we submit that that appointment itself was unlawful. But there was also,
sorry to interrupt you, is there a specific prayer sought in your notice of motion that the appointment of Justice Kampempe by the President should be set aside?
No, there isn't. There isn't. With respect, it's a matter that on the facts that are available, we submit that the court would be entitled to impugn that particular appointment on the basis that it was simply not tenable for the President to have done so. Bearing in mind that the President receives advice from his Minister of Justice, and bearing in mind that the Chief Justice was also involved in the particular appointment, we submit that it's not necessarily, it would have been prudent for us to ask for that particular order, but it is one of those collateral challenges that are possible to raise in the course of this litigation, where it's clear that the power exercised by the President was on the prompting of a Minister and Acting Chief Justice who believed that it was lawful to appoint a member of the judiciary to the JSC via the appointment of an acting, via the provisions of the Constitution on acting appointments of judicial officers. So we would submit that we don't seek a specific order, but we submit that this is one of the challenges we could regard as a collateral challenge that the court is entitled to make in the event that it agrees with us that on the law, the President could not have appointed a member for a day simply to perform a JSC function.
Sorry, Mr. Masuku. On that point, before you move to the next one, can we just make sure that we're asking ourselves the right question? Isn't the question this? Was there a vacancy which the President could fill with Judge Kampempe in the role of Deputy Chief Justice? Because the then Deputy Chief Justice was the Acting Chief Justice. Isn't that the vacancy that we have to decide whether or not it's lawful to fill? If, for argument's sake, it was lawful to fill that because there was a vacancy, then there's no challenge to that. And then automatically, whoever is now the Acting Deputy Chief Justice would be eligible to be a member of the JSC, as distinct from suggesting that what the President did was fill a vacancy on the JSC. Is it appropriate to draw a distinction between those two questions? And if so, which is the right one to answer?
Justice Sutherland, the question, on the authority of the Supreme Court of Appeal in the JSC versus the JSC versus the Cape Bar Council, and the Judge President Hlophe versus the FUL. The FUL versus. Sorry, Judge Sutherland. My junior is whispering at me. And sometimes that. Yes, sorry. So that Supreme Court of Appeal case, which I'm trying to formulate correctly, which is Hlophe versus FEL and the Premier. The question of vacancy does not arise because it couldn't be suggested in the presence of the acting in the presence of Deputy Chief Justice Zondo that there would have been a vacancy. As you recall, Justice Sutherland, what happened there was that the motivation by the Judge President, by the Chief Justice and the Minister, was that there was somehow Justice Kampempe was seized with the matter because she had chaired one or other meeting of the JSC, and therefore it should just continue. So the appointment was for a day. It was for a day, a single day, and it's specifically designed to fill a vacancy in the JSC and not to fill a vacancy in the judiciary, which would be the power that the president has to appoint an acting appointment of a judge. So I would submit, therefore, that that's the first basis on which we contend that the Justice Kampempe was not lawfully appointed to preside over the JSC. For that, there is no lawful basis for it. But there's also a further basis, Honorable Court. The further basis is that Justice Kampempe was part of the panel of in the Hlophe versus the JSC matter, which was in the Constitutional Court, which we've referred to in our heads of arguments. She was part of the panel that decided that in order to protect the integrity of the Constitutional Court processes, it was not advisable for the Constitutional Court to deal with the merits of the appeal. And the merits of the appeal was really whether or not the JSC, the 2009 JSC finding that exonerated Judge President Hlophe should be upheld. It was really just that. It was really a merit, an issue on the merits. What we're asking the Constitutional Court to do was to get involved in evaluating whether or not the SCA had been correct to say that the absence of the Premier of the Western Cape and the failure to cross-examine were so grave illegalities as to vitiate the favorable finding that Judge President Hlophe at the time enjoyed. So in circumstances where Justice Kampempe took the view as part and parcel of the bench in that particular case that she would not be involved in determining the merits of the appeal, it is just simply wrong for her to have taken the view that it was competent for her to appear in the JSC to decide essentially the same questions. And we submit that that judgment was binding on her, and it was binding on her when she appeared before the JSC, and she should not have taken the position. But it also raises just...
Sorry to interrupt you, especially on this aspect. I just want to be sure that I understand.
Yes, sir.
When you presented your argument in respect of Justice Mba, you said the Constitution does not make provision that the President and the Deputy President can appoint an alternative, right? Now, in this instance, in respect of Justice Kampempe, the Chief Justice, Deputy Chief Justice, President, and Deputy President were not available, or were not temporarily available, or if they were not temporarily available, does the Constitution make provision that the president can appoint an alternative.
Not in the provisions, not in the controlling provisions of the Constitution. Section 178 does not provide that the president may appoint an alternate to the Chief Justice or the Deputy Chief Justice in the event they are unavailable. What Section 178(7) says is that if the Chief Justice or the President of the Supreme Court is temporarily unable to serve on the Commission, the Deputy Chief Justice or the Deputy President of the Supreme Court of Appeal, as the case may be, acts as his or her alternative. These are already established offices. What is sought to be defended by the JSC is a situation where all the four functionaries all the four judicial officers are unavailable. The Chief Justice, the Deputy Chief Justice, the President, and the Supreme Court of Appeal President. That in order to fill a vacancy, it is competent for a Deputy Chief Justice or a Chief Justice to then approach the President to appoint any member of the judiciary as a Deputy Chief Justice or acting Chief Justice for a day in order to fill a vacancy in the JSC. That's simply not in the Constitution. It simply is not in the Act, the JSC Act. So we submit that that too is a problem, because the President is not authorized in terms of the Constitution to appoint a member of the judiciary to act in the JSC. The President is authorized to appoint a member to act in the courts, not to appoint that member, which is the argument that my learned friends for the JSC and the others make, which is that the important issue is that the President appointed a justice to the position of acting Deputy Chief Justice. By virtue of having done so, that person became competent to sit in the JSC. But that's a different issue. The reason why that individual was appointed as acting Deputy Chief Justice was to preside in the JSC. It was not to perform judicial functions, as would be the case normally when the President appoints an acting justice to the Constitutional Court. It was to preside in the JSC. And we submit that it is not competent for the JSC, for the President, to have appointed any member of the Constitutional Court, in this case Justice Kampempe, to act in the JSC, which is what happened. In that day, Justice Kampempe did not perform a judicial function. She performed a JSC function. And one could argue that, well, the JSC function was in fact a judicial function. But that's an argument which takes the matter nowhere, because it would simply distort the integrity of the constitutional meaning that must be assigned to the President's power to appoint a justice to the Constitutional Court. And it would, in fact, we would submit that it would violate exactly what the Constitutional Court warned in the Hlophe case, where in the Hlophe versus the JSC and the Premier of the Western Cape and the JSC, where the court warned against inviting acting appointments to the Constitutional Court simply to fill the quorum for a specific case, and the Constitutional Court said it was not desirable for the President to be invited to act in that way, because that may well be interference with judicial independence. But so we submit that Justice Kampempe's appointment to chair the JSC meeting for a day was not lawfully done. But added to that, with respect, the recommending authority, in this case, the Deputy Chief Justice, the acting Chief Justice, Justice Zondo, was part and parcel of the panel in the Hlophe case, in the Constitutional Court, where they took the view that they couldn't sit because it would not preserve the integrity of the processes of the Constitutional Court for members of the Constitutional Court to determine the merits of this particular matter. Being conflicted in that way, the Chief Justice should have not recommended somebody that they'd sat together in that particular judgment and said, well, you can go, but I can't go. That's simply a failure to apply their mind to the question of who is the appropriate authority that may be appointed, because that appointment, with respect, undermines that particular Constitutional Court judgment in the sense that it is appointing a member who has taken a view that they are in fact conflicted to serve, to adjudicate the specific matter that they are now being asked to adjudicate in the JSC. So if the president had been appraised of the correct facts, the president would have said, but no, wait a minute, you asking me to appoint for a day Justice Kampempe, who in the judgment of Hlophe versus the JSC, or the FUL and Premier, who took the view that it was not proper because for them to hear the merits of the case. You want that same judge to then go and hear this matter elsewhere in the JSC. I mean, it doesn't seem to me to preserve the integrity of the appointment process that must be done in a manner that does not undermine a judgment of a binding judgment of the Constitutional Court, that also doesn't undermine the constitutional, the rationale behind the constitutional power to appoint an acting justice of the Constitutional Court. The president would not have appointed a conflicted member of the panel to the JSC if he had been told that that was the case, which is the case in this particular matter. Then, if we, and I use this very loosely, if we knock out Judge Mba and we knock out the Justice Kampempe, then the JSC did not have the majority. Simply did not have the majority to make the finding that it did, and the two judgments that I'm constantly referring to would be dispositive of that particular matter.
Do you mean majority or quorum?
I beg your pardon, sir.
I'm missing the point. When you say that the JSC did not have power, are you saying that they did not form a quorum? Or are you saying that there wouldn't be a majority vote that JP Hlophe?
Yes, that is the submission I'm making, and let me elucidate on that submission.
Because I read somewhere that those who were in favor or who recommended that there was a gross misconduct were 8. So if you minus 2, we still have got 6, which would be the majority. And those minority were 4.
So the majority, the majority would have been if we as I say use this word knock out. If we knock out Justice Mba and we knock out the Justice Kampempe, of the 8 members, not sure whether there were 8 or 9. There were 9.
8.
There were 8. So of the 8 members, we now have 6. And that can't be the majority, because the majority, according to the judgment of the SCA in the Hlophe and the Cape Bar Council matters, require that 7. It requires that there are essentially 15 members who sit in the JSC, if all of them are sitting, and if the matter is one where the Premier or a representative of the JP must be present. So they have to be 15 members. So if we knock out 2 of those, we have, so the quorum would be, if it's 15, then it would be 7.5. I mean, that's not, there's no half, but it would be, let's say 8. 8 would be the majority out of the 15. But so if we remove 2 of these, then you don't have a majority. And the Constitution, the Supreme Court of Appeal was quite strict on its interpretation of the composition point, because they said that the majority is not of members present. The majority is the stipulated number in the by the Constitution, and the number stipulated in the Constitution is 15. If the matter is one where the Premier has to be there and where the JP's representative have to be there, then there are 15. So you have to find 8. You have to have 8 members of the JSC supporting the outcome. But of the majority that we have, which is 8, then we don't have a majority, because the majority has to be 8. So if 8 of them were Judge Ledwaba, I think Judge Sutherland is now off your screen. I think he just left. I saw the sign leaving.
DJP Sutherland, are you still with us?
No, I did see sign saying I'm leaving. I'm not sure. Sure.
I think there's a difficulty with the Wi-Fi at the moment. I had a difficulty, but it seems to have resolved itself. Maybe the same is happening to DJP Sutherland.
Yes, I'm sorry, I just lost connectivity.
Those are the wars and tribulations of a virtual hearing.
Oh.
But
I don't think DJP Sutherland could have missed anything, because you're still just making your point that the majority is at least 8.
Yes, so would submit that if 2 of them are removed from the majority, then you have 6, and that 6 is not the majority. And I was making the point that the Supreme Court of Appeal, which is the binding authority on the interpretation of the composition of the JSC, simply left no option of interpreting Section 178 to mean members of the JSC available in that meeting. In other words, if there were 6, 4 of those would be in the majority. If there were 8, 6 of those would be the majority. The JSC basically said the members of the majority must be the members of the entire group, and the majority therefore must. So if 8 of them were sitting, then all 8 of them had to agree with the outcome, and that would have been a properly composed majority. It doesn't answer the question, and I can see Judge Sutherland it hits my own argument, which is that the SCA has said if the Premier is not there, then you don't have a properly constituted JSC. If the Supreme Court of Appeal justice is not there, then you don't have a properly constituted JSC. So the argument is a stricter one, is a more stricter than the argument I'm advancing, which is that on the point of composition, there's simply no option but all the members that are set out in Section 178 ought to be there. That's simply what the Supreme Court of Appeal requires of the. That's how they've approached the constitutional that provision. Because if they had approached it in the way that we'd submitted in 2012, when this matter was argued in the Constitutional Court and the Supreme Court of Appeal, where we said you have to accept that there are certain members of the JSC who may feel, like in this particular case, who may feel that they are conflicted and therefore cannot sit. The Premier, for example, could have said, no, I'm not available because I'm conflicted. But the Premier is one of those functionaries who could have gotten an alternate member. So that saves the Premier. The Supreme Court of Appeal President, similarly, is one who could say, no, I'm not available, but the Act allows that if the Supreme Court of Appeal President is not there, the alternate is the Deputy President. So, but the Supreme Court of Appeal, which is the controlling judgment on the composition aspect, makes it clear that you have to have a majority of its members, and majority is the number that is plus 1 of the half of the 15 of the 15 members that would be present in that particular body of the JSC hearing the matter. So it is one issue, one ruling of the SCA just being adventurous, that I would like to see changed, because it simply makes it difficult for members of the JSC who have a conscientious objection to sitting in the JSC for reasons of conflict to be unavailable, because to be unavailable potentially renders collapses the JSC quorum. And as I submit that the unavailable if we remove Justice Kampempe and we remove Justice Mba, then you don't have a majority. So that would be the third basis on which to set aside the JSC. So if you knock those two, then you don't have a majority. Then of course there is no binding finding of the JSC. And then, I mean, there's a lot. I'm going to, in reply, perhaps deal with the issues. I've made submissions in relation to whether or not there is room to argue that the President of the Supreme Court of Appeal and the Deputy President have the power, whether in terms of the Constitution or in terms of any other law, to substitute their appearance in the Act. I've submitted that they simply don't. If they are not available, the legislation controls what happens. It says that the Judge President would be members of the JSC would elect the Judge President. But that also doesn't resolve the issue of composition. And I would invite the court to carefully look at the two judgments to see what the SCA has done in order to interpret Section 178. And for the court to appreciate the difficulty that the position creates for how the JSC resolves its own questions. It leaves no room for anybody to argue that a member as important as the president of the SCA could simply be unavailable. And it does interpret the word vacancy, and a vacancy does not include recusal, according to the JSC versus the CP, the Cape Council judgment. You'd have, I mean, so in the JSC versus Cape Council, the court found that the presence is required. The presence of the Chief Justice and the President of the SCA are required for a valid composition. And you see that in paragraph 35 of that judgment. They say for the valid composition of the JSC, those two have to be there. It would not suffice that either the CJ or the President were simply not available. More is required, namely that they are unable to serve before the deputies could be designated as alternates. So, I mean, the threshold for absence in the JSC is quite high in terms of the judgment of the Constitutional Court. It's more than just saying we're unavailable. More is required. We're unable to serve. And perhaps when somebody says I'm conflicted, they're essentially saying the jurisdictional basis on which I can actually preside over the matter is not there. I have to be independent. I have to be perceived to be independent. And if I don't present that particular quality, I'm unable to serve. And maybe that is the interpretation one must give of what unable to serve would mean. But these are the hurdles that mercifully this court would be required to deal with.
Mr. Masuku, sorry, I'm having difficulty unmuting my video. What do you say about the JSC's argument that Justice Kampepe's appointment as acting Chief Justice in terms of Section 4.2b of the Superior Courts Act was proper? Chief Justice Mogoeng was on long leave, he was absent, and then in terms of Section 4.2b of the Superior Courts Act, Deputy Chief Justice Zondo exercised his powers.
Yes.
What do you say to that argument?
To that argument, I say that the appointment would have had to be an appointment to perform a judicial function. It would have had to be an appointment to a court. It is not envisaged that the president will exercise the constitutional power to appoint a acting deputy chief justice for the sole purpose, for a single day, to perform the JSC functions. And that's really the thrust of it. We say that according to the JSC itself, the JSC says the Justice Kampempe was appointed for a day to perform only the JSC functions. And the motivations for that are set out in the letters that were written by both the minister and the Chief Justice. So our submission would be that it would be an appointment for, perhaps put differently, it would be an appointment for an improper purpose, which was to serve in the JSC.
Yes, but
when the JSC itself regulates how that appointment, sorry, just cut it.
Then what about the section 1751 of the Constitution, where a person, if there's a vacancy, or if the person holding such an office is absent?
Sorry, what provision is that?
Then the cabinet member responsible, with the concurrence of the Chief Justice, and make an appointment as acting Deputy Chief Justice from the ranks of the judges of the Constitutional Court.
Yes, there was simply no vacancy.
Yes, but it also says, or if the person holding such office is absent.
Yes, so it's absence in the Constitutional Court, not absence in the JSC. So the argument we advance is that the president could appoint Justice Kampempe, but it would have been for the judicial purpose, for a purpose to serve in the judiciary. She performed not.
Right. No, and thank you, Mr. Masuka. Noted.
Yes, we continue.
Yes. So. So, justices, you will find the arguments I'm making set out in the JSC versus Cape Bar Council in paragraphs 24, 25, 26, 27, paragraphs 30 and 31. Paragraph 31 deals with the meaning of unavailability, and that is where we make the submission that simply the absence that the Supreme Court of Appeal envisaged was the one which it said was underpinned by the maxim lex non cogit ad impossibilia, where there simply was an impossibility. Then there could be an absence. But it said in paragraph 30, it follows that if the JSC cannot take a valid decision in the absence of, the JSC cannot take a valid decision in the absence of either the president, the premier, or the JSC. The position is no different to when it say that if a JSC cannot take a valid decision in the absence of the premier or the absence of the JP's representative, then the position is not different when the absence is that of the president of the SCA or the deputy president of the SCA. Justices, may I then address the issue of composition? We say, obviously, if we successful on the issue relating to the composition of the JSC, then that is the end of the matter. The court would follow what the Supreme Court of Appeal said about this particular situation where the composition is not proper, and set aside the JSC decision. I did promise that I would address the issue of remedies at the end, but just to flag them now, the remedy, we say a just and equitable remedy has to take into account the conduct of the JSC from 2009, from the time that this matter was started in 2008 up to date, where the JSC simply can't get it right. In violation of Section 178, therefore, we submit that the Chief Justice was not present. The Deputy Chief Justice was not present. The member of the Supreme Court of Appeal was present, was not constitutionally entitled to appear in the JSC. And therefore, and of course, we've made submissions in relation to Justice Kampembe, that her appointment to that position was impugnable at two levels. The first one is the application of the judgment, in which she said she could not sit and adjudicate the merits of the complaint, because to do so would be to undermine the integrity of the constitutional court processes. And if she had taken that view, she said simply shouldn't have taken the position to adjudicate the merits of the complaint in the JSC, because the same basis on which she refused to be part of judges that could hear the merits of the application applied equally when she was appearing in the JSC itself.
DJ Hlophe, might I suggest we take an adjournment at about now?
Okay. Let's take an adjournment. Can we do it for 10 minutes?
It is well.
Okay. So we'll adjourn and we'll resume at 11:30.
Thank you, Judge President.
Mr. Masuku, you may proceed.
Thank you, Justice Hlophe. May I then move to our part A of our heads of arguments? We submit in relation to part A that there was a complete failure by the JSC to apply the correct law to the issue of determining judicial misconduct. The fact that the JSC finding, the majority JSC findings, and the JSC tribunal findings report do not mention a single word of presumption of judicial independence. It's just a complete failure to appreciate the duty imposed upon them to determine a question of whether to withdraw from Judge President Hlophe presumption of judicial integrity on the basis of the alleged conduct which he was alleged to have committed. Honorable Justices, in this regard, the JSC as well as the tribunal failed to answer a pertinent question that was before it and failed to apply the legal principles that were available to the JSC and the JSC report. You will recall at the beginning of my submissions, Justices, I referred to the principles that are referred to often when a court is dealing with allegations that a judge suffers from bias. And I said what the courts generally say is the threshold to dislodge that presumption, which is extended naturally. And I say naturally because the office of a judge is presumed that it is an office of integrity, an office of probity. It is presumed. So it should not be light to presume that a judge who holds a conversation with another judge has improper intentions. In order to dislodge that particular presumption, which is extended to all the judges that are involved in the complaint, in order to dislodge it, you've got to allege a bit more than simply saying one judge expressed views that the other felt uncomfortable with. Because the essence of the entire complaint is that Judge President Hlophe made certain comments about a pending judgment. The other judges felt uncomfortable, and therefore he's guilty of gross judicial misconduct because the expression of those particular views had the intention to undermine the oath of office of the judges to whom he was talking. So we have to find in the conversation between those judges an intention. And we say that the JSC starting point should have been, there is a presumption which operates in favor of Judge President Hlophe, operates in favor of Justice Jafta and Kabinde. And that presumption is that judges will not engage in private conversations that are intended to undermine their own oath of office. So a reasonable person judging those conversations ought to ask the question, knowing what we know about the office of the judge, which is that a judge takes an oath of office to be independent, to apply the law without fear, favor, or prejudice, knowing that a judge's position is venerated by society as one which is prestigious, which carries with it an enormous responsibility of detachment and of serious integrity. Knowing all those factors that are extended to judges, what is it about the conduct of Judge President Hlophe that the tribunal and the JSC found dislodges the presumption extended to him? Presumption that he would not engage in lawless activities as a judge, particularly when he speaks to other judges. And I say particularly when he speaks to other judges, because I can't guarantee what any judge says to another person they meet in their own private homes. But when you engage with another judge, you assume and you presume that judge's independence. You assume that whatever you say as a judge to another judge, that judge to whom you are saying whatever it is you are saying, will not presume that you have improper motives for saying so. And perhaps let me dispose of this argument, this submission pretty quick. At the hearing in December, Judge Jafta and Kabinde withdrew the allegation that had powered this particular complaint for a number of years, which was that Judge President Hlophe persuaded or attempted to persuade them to violate their oath of office. And of course, you will have seen that in 2009, the JSC spent a commendable time distinguishing between persuade and influence. And they say, well, persuade would be the vehicle of influencing. In other words, in order for the allegation that he intended to influence judges, he must do something more than just have and express a view or make a remark. In other words, and this within the context of these presumptions that I've mentioned, the presumption of judicial integrity, the presumption of judicial independence, and the presumption of judicial impartiality. Within that context, there's got to be more than just holding a view and expressing it to a judge who is engaged in writing a pending judgment. You've got to do more than just express a view. You've got to persuade them in order for them to feel, to form a view about whether or not your intentions are to violate, for them to determine the matter in accordance with your persuasion. Now, we don't have persuasion in these allegations. In the allegations that are against Hlophe, it's made clear by Justice Jafta and Kabinde in evidence. It's made abundantly clear. In fact, it's recorded as an amendment of the statement that was made by the Constitutional Court judges, in which it was alleged that Judge President Hlophe sought to persuade judges. They made it clear that that did not happen. They specifically asked on that particular issue after they'd made those changes, and they confirmed that they consider what the Constitutional Court said in that statement in relation to whether or not there was a persuasion exercise engaged in the conversation, that it was not so. So once you remove the act of persuasion, what are you left with? You are left with remarks that are made on a pending judgment. So Judge President Hlophe remarked on these pending judgments. That's all we are left with. Where does the intention to influence the outcome of the judgment or to undermine judicial independence arise from? It can never be suggested that a reasonable person in a position where that person knows the oath of office of the judge, the experience of the judges involved, the level at which they are engaged in their respective judicial duties, that it would be presumed that that conversation between the judges was a conversation intended to subvert Section 165 of the Constitution, as the report of the tribunal and the JSC found. And had the JSC and the tribunal utilized the correct legal principles, which is the presumption of judicial independence and the presumption of judicial integrity, they would have judged this matter differently. What they've done is to come up with a finding that will place the office of the judge in an untenable position, where a judge can be found to have grossly misconducted himself for simply making remarks on a pending judgment without the element of persuasion. So once the two witnesses to the conversations had testified that there was no persuasion or there was no attempt to persuade, and that There was no attempt to say, please rule in favor of so-and-so, or rule in favor of so-and-so, or that you need to go this way or that way, because of a discernible interest. That would have been the end of the complaint, in the absence of more than persuade, of the element of persuasion. But of course, we know that the principle that the JSC upheld, which developed from, and I will refer to the tribunal's evidence of this rule, that judges on appeal, that judges in the High Court cannot make remarks to their friends who are in the appeal court on pending matters. That rule is not written, it's not anywhere. You don't learn it from the School of Judicial Ethics. It is part and parcel of a judge's instinct of what it is to be fair, or how it is to be fair when they exercise their judicial authority. It is an instinct born out of experience, either, as they say, either as a practitioner of law in the bar or as an attorney, or just your inborn sense of what it is to act correctly. So it is hunch. And as we say in our heads of arguments, the only regulators of private conversation between judges are judges themselves. They know when a judge's expressions have exceeded what is legitimate. The fact that a judge, and let me make this point to buttress the point I've just made. The fact that the judge feels uncomfortable with a remark made by another on a pending judgment, the fact that a judge does not agree with a remark made by another judge in a pending judgment does not ground a finding of gross judicial misconduct. The discomfort of a judge is not evidence of misconduct, because judges will know that amongst themselves are rigorous debates, discussions in their private conversations, which the Code of Conduct now validates as acceptable conduct. They know when a judge has, when the presumption of integrity accorded to a judge may be withdrawn. So let's say, for example, Judge Hlophe showed up in the offices as previously alleged, which is not pursued anymore, uninvited, so they say. He shows up in chambers of somebody uninvited and says to the person, you know, if you, this Supreme Court of Appeal judgment is completely wrong. You guys must rule in favor of the NPA, or in favor of President Zuma, or in favor of the tallies. Just rule in favor of them. And I have in my bag, I have a brown envelope that may assist you in how you think about this case. It's got a significant pink paper, which is money, that may encourage you to enjoy other things of life for this particular outcome. That's definitely criminal. That would definitely be inappropriate. And a judge would be justified to not only say, please stop, but to go further and say, but it's not just the fact that you expressed your views about this case. You actually asked me to subvert a sacred, a sacred oath that I take on behalf of South Africans to not act corruptly in the pursuit of my duties. That's what you did. But I mean, right now, the community which judges serve are asking themselves, do judges really speak amongst themselves? Do they ever make remarks about a pending judgment? Because according to the judgment of the SCA, this rule, sorry, the findings of the JSC and the tribunal, this rule, although unwritten, is elementary. Everybody knows about it. I'll deal a little bit with why you should reject the evidence of the tribunal members with regards to the existence of this rule, and why you should also disregard the evidence of Justice Mlambo and the other justices, or Justice Mba and Justice Kampempe, who then said this rule does exist, because that evidence was not evidence before the tribunal, and it appears that that is the evidence that determined the direction of the majority JSC. In other words, the question and I'll refer, and we do refer in our heads of arguments to the test that is adopted in Canada, which is a test that we have adopted when we deal with questions of recusal, or where a judge is asked not to preside over a matter because of one or other conduct that renders him conflicted to deal with the issue. In Canada, what the Judicial Services Commission of that country has done is to formulate a very succinct test, which is, when you look at the conduct that is impugned, you must ask yourself the following question: is the conduct so manifestly and profoundly destructive of the concept of impartiality, integrity, and independence of the judicial role that public confidence would sufficiently be undermined to render the judge concerned incapable of executing the judicial role? So the question is very profound in that it captures exactly what would be applicable in South African context, where you are dealing with recusal. And one has to look at how SAFU, in the SAFU judgment of the Constitutional Court, in the Bennett case, and in the other cases that have dealt with the presumption of judicial independence, that the threshold for holding that a judge is the presumption of integrity can be withdrawn from him is high. It is absolutely high. And here what we say, if drawing from the Canadian experience, is the JSC should have asked the question within the prisms of this principle of judicial independence and judicial the presumption of judicial independence and the presumption of judicial impartiality. They should, within those prisms, they should have asked the question: is the impugned conduct so destructive of the concept of independence, impartiality, integrity, and independence that public confidence would be undermined if the judge continued to play the role of a judge? Of course, that test would immediately place Judge President Hlophe out of the public confidence aspect. Judge President Hlophe has continued to be a judge president since this complaint was put in place, or since this complaint was lodged. He has served written judgments, performed his judicial role since the complaint. So the public confidence test is met if one were to use the test, which we believe is applicable in our situation. You have to ask yourself, in relation to the facts of this case, and remembering that the person, the standard that the law requires is a standard of a reasonable person who knows all the facts, who knows the law, and who understands the office of a judge. In other words, understands that the judges who engage in a private conversation have taken an oath not to engage in inappropriate conversations that violate their oath of office. A reasonable person is one who knows that judge against judges is a ironclad presumption of judicial integrity and judicial independence. That is the person we're talking about, who would have known that in order to withdraw the presumptions that are accorded to judges, the threshold had to be higher than normal. So you would have had to find in this case, in the absence of persuasion, which no longer exists because the judges concerned were witnesses, were very clear about that aspect. They said, no, we're not persuaded by Hlophe. He never persuaded us. He expressed his views. We found them inappropriate. Putting it together, in fact, we submitted that they were reluctant witnesses, in the sense, and one can see the difficulties they had. They had taken the view right at the beginning, which is the basis of their statement of the 12th of November, that they had dealt with whatever was inappropriate in terms of the conversations they'd held with Judge Hlophe. Judge Jafta, if Judge Hlophe had only visited Judge Jafta, nobody else, we would not be here. These 12 years would not be as horrible as they've been to Judge President Hlophe and to the community that he serves. It would not be an embarrassing moment for judges, because Justice Jafta was very clear. He felt uncomfortable. He said to Judge Hlophe, I know the matter will be decided in accordance with the law and the principles applicable. And when he's specifically asked there, Judge Jafta says, Hlophe appeared to understand, he changed the subject, spoke about something else. That was the end of it. Judge Nkabinde says, you know what? I went to a workshop where they were training people how to deal with difficult matters involving sexual harassment and all those things. And one of the things she learned there was that if you have a problem with a particular individual, you firstly confront that individual and you set out what your complaint is. When then you engage with that person, if obviously the complaint is bigger than engaging that person, what you do is you escalate it to somebody else. And in this case, it would be the judge. It would be either the judge president, the deputy judge president, or even the chief justice if it's the Constitutional Court. You'll see in Article 16 of our Code of Conduct. Justices, can I just? I thought I had my copy of that. Can I just get that from? Can I get Code of Conduct? Code of Conduct. But it's Article 16, to my recollection. Which essentially mirrors the law at the time that this complaint was lodged, or the position at the time this complaint was lodged. I will get the specific. I had it in front of me, but I don't know what has happened to it. I think Hlophe must have taken it away from me. Justices, please bear with me. But as I say, it's in Article 16 where it makes it clear that if a judge has a problem, I think it's Article 16.3. It says where someone has a judge has a problem with another judge, they ought to raise the issue with that judge. If the matter is sufficiently grave, then they ought to report the matter to the senior member of that court or the head of that court. But it doesn't mean that a judge who feels seriously, particularly angry about an inappropriate conduct of another judge, and believes that that conduct is inappropriate, that judge is entitled to also raise a complaint with the JSC. Article 16 says reporting inappropriate conduct. And Article 16.3 says a judge who reasonably believes that a colleague has been acting in a manner which is unbecoming of a judicial officer must raise the matter with that colleague or with the head of the court concerned. And we say that, and here we've made arguments, and we're very careful not to make arguments that stretch as far as trying to impugn the conduct of Justice Jafta or Nkabinde in how they conducted themselves. We accept that they were in a difficult position when they were confronted by 13 other judges who were looking at what had been reported to them, and I'll come back to what had been reported to them, and say to them, no, but this issue must be decided by the JSC, because this issue raises concerns about whether or not Justice Hlophe's remarks or his conduct. At that time, it was a conduct that included persuasion, an attempt to persuade these judges to violate their oath of office. So we say that if the court were to adopt the approach that courts generally adopt in matters that involve recusal, which is in itself, as in Dilasi, then acting Deputy Chief Justice Museneke, describing what the actual implication of an application to have a judge recuse themselves. He says it's actually an application that's so serious because it implies that a judge will not act in accordance with their oath of office. And so he says, well, the presumption of judicial integrity, presumption of independence, can only be dislodged in accordance with a standard that of a reasonable person who is familiar with the office of a judge, who's familiar with the fact that a judge takes their oath seriously and the presumption that are extended to them. So we say you can look at the report of the tribunal and look, the reference to presumption of judicial independence is only referred to where the judges are exposing, and I say exposing, their bias. And I take it as high at that level as to say that they were clearly biased, because one looks at what the tribunal said in paragraph 122 of their report, where they say, and you will see that this whole report was an exercise in vindication of the integrity of other justices. And you'll see that it's not just other justices, it's also in vindication of witnesses, judges who had been witnesses. That's quite inappropriate. They say we align ourselves with these remarks in the context of the facts before us. We consider it our duty to vindicate the integrity of justices of the Constitutional Court, in particular, Chief Justice Langa, Deputy Chief Justice Mseneke, Justice Nkabinde, and Justice Jaft, whose integrity has been called into question by the judge president's unfounded and scurrilous attack. They acted with honor to protect the institutional integrity of the apex court of our republic. A judge must not do that. A person who has taken an oath of office to apply the law without fear, favor, and impartiality ought not to see their role as vindication of one witness as against the other. And bearing in mind that they find nothing wrong with the evidence of Judge President Hlophe. They don't make any findings in terms of the credibility of Judge President Hlophe. But they see their role, and one reads their judgment or their report and sees how they simply dismissed everything that Judge Hlophe raised. No effort to deal with the specific complaints Judge President Hlophe had raised with thoroughness, with the sensitivity that it requires, and with fairness, including the fact that Judge President Hlophe was charged. Charges against him were preferred. They say, well, it's not necessary to have charged him. But as a fact, he was charged. He was treated like a criminal before the JSC. There was a charge sheet. They say, well, it doesn't matter. You are not prejudiced by that. But if one looks, if they paid attention to the idea of presumption of judicial integrity, they would have said it is not appropriate for an institution like ours to present a charge sheet against a judge, because to do so is to suggest that a judge has committed a criminal offense, or an offense of a nature that ought to be couched in judgeship. That whole mundane way of, looking at the gravity of being charged. So when society looks at Judge President Hlophe, they look at Judge President Hlophe, someone was charged with criminal conduct. In fact, it's suggested on behalf of the Constitutional Court judges it's suggested that by a member of FUL, the leader of FUL, former Justice Crickler, that Judge President Hlophe potentially committed a criminal offense. This is said in public by Judge Crickler. And then at the JSC, their charge is made against Hlophe. And the tribunal says makes nothing of that issue, because their primary philosophy, which was a faulty philosophy, was they saw their duty as to vindicate the honor of justices of the Constitutional Court, and they mentioned them by name, and that is inappropriate. That should not have been endorsed by the JSC, and the JSC appears to have taken more or less. The JSC endorses it. It doesn't say no, but we can't have a tribunal that has conducted an investigation to this issue, heard both sides of the issues, and then sees itself as having a duty to vindicate one party as against the other. That's simply a procedural irregularity of the nature that the courts would find would find inconsistent with the office that these members of the tribunal were holding. The second aspect that we contend the JSC failed to do was to look at what the tribunal said about the existence of this rule. And you'll find that in paragraph 87 of the ruling, of the report of the JSC. And you'll also find, I'll just find the paragraph in the JSC, in the discussions in the transcript of the meeting of the, is it 25th of August, if I'm not wrong, where Justice Judge President Mlambo invokes his over 20 years of experience to support the existence of this particular rule. This is what they say and I'm talking about the tribunal. They say it is also the lived experience of members of the tribunal who are members of the legal profession as judges and practicing attorney. And I just pause there. There was no evidence from members of the legal profession or practicing attorneys that could remotely support the existence of a rule who's so amoebic in its nature. This rule is amoebic. It's a rule in terms of which is acceptable for a judge to invite another judge to come and comment on a pending matter. So if you are by invitation brought in and we are asked, hey, please, man, tell me where do we go with this case? I have a problem with ABCD. I don't know how to apply this particular principle to these particular facts. What do you think? And the judge invited might well say, look, let me read what you have written and let me just engage with the issue, having read a bit more. Do you have heads of arguments of these people? I can read, and then I can give you a view of the question you're asking me. They say it's okay. It's okay to do that when you're invited. But they don't go as far as saying it's not okay, even when you're invited, to supplant your view of the judge sitting in the matter. So the understanding of that rule and its modifications, because it's unwritten, it really is a perception that a judge must formulate on their own. When you are invited, it's okay, but when you are not invited, it's not okay. So the evidence that they ought to have paid rigorous attention to was the evidence of Judge Jafta and Justice Nkabinde and Judge President Hlophe. Judge President Hlophe said, in the high courts, we regularly speak amongst ourselves. We remark on pending judgments. We engage in discussions on pending judgments. There's never been an issue. So when I'm meeting my friends in a social occasion or my colleagues in a social occasion, knowing what I know about judges of the Constitutional Court or Supreme Court of Appeal, presumption of judicial independence, knowing what I know about them and the oath of office they hold, I could make these remarks without believing that they would think I am trying to influence them in a different direction, particularly to violate their oath of office. And I'll come back to the content of what is alleged to have said, because if one looks at the content of what is alleged to have said, no self-respecting judge could be influenced by what he said. A judge would read the record, who had looked at the issues more thoroughly than he had, because he was simply relying on what was said in the public domain, and maybe having read one of the judgments of the Supreme Court of Appeal. So the injection into the evidence of the members' lived experiences to decide the question of the existence of the rule was invoking a subjective mindset into a matter that required objective inquiry. And here you'll see that they go as far as, and I say misrepresenting the rule because the rule is not written. So no one can really tell us in its written format what that rule would look like. Judges would know, and they would tell you, okay, this rule is it's really a matter of judgment. A judge must have the right instincts to know when to stop an inappropriate conversation. And if a judge can simply shrug it off their shoulders and continue to do their job independently, that's what is expected of them. But they say that principle is deeply rooted in the legal profession. I mean, members of the bar would know, we know as members of the bar, the members of the attorney's profession, that we regularly speak among ourselves about our own matters. If I'm having struggles with a particular principle, as I had preparing for this matter, I'd go next door to my friend Darrell Cook, and I'll say, Mr. Cook, you know what? This rule they say is nailing my client to the cross of judicial misconduct. But this rule is not written. And then Mr. Cook says, but you know, Tabani, I thought of a judgment in which it was specifically say that a rule on which to find someone guilty of must be clear, written, and published for every individual to know what that rule means. We know that this rule is not published anyway. We know that this rule is not, there's no notice to all the judges of the High Court that they may not make remarks to their senior colleagues in the appeal court on pending matters. So they can have a braai or go hunting or go to church together, but when they meet each other, they must rigorously avoid making any views they might hold about so public a matter like the Zuma matters. Known, hey, my friend, you know, this is a very difficult matter. I assume you guys are really engaged in a miasma of a case. It's not just difficult from the point of view of the legal principles involved. It's also difficult from just what it represents and who are involved in the matter.
Can I pose a question to you at this stage?
Yes, yes, Judge.
You've devoted quite a lot of energy to trying to capture the social dynamic amongst judges in various circumstances, both formal and informal. But interesting as that may be, isn't the nub of the issue which we are taxed with is whether as a fact on the evidence presented, it can be inferred that it was an attempt to persuade the judges, a failure in any event, but an attempt to persuade the judges to decide in favor of Mr. Zuma. Now, can there be any debate that a person who is fit for office as a judge is so lacking in character, is so lacking in good judgment, that he or she would not instinctively grasp that you may not go to a colleague and suggest that that colleague who is hearing a matter in which you have no role should find in one or other litigant's favor? Can there truly be any debate about that?
Well, firstly, the factual premise of your question, on the factual premise of your question, yes, I don't believe that I can debate with you that aspect. But let me posit the correct factual questions, so that we are not speaking cross purposes in relation to this particular case. Can never be suggested, knowing what we know, that the two judges themselves, who were witnesses to this particular conversation, are not asking for, we're not asking for the tribunal to find gross judicial misconduct. They would have been under a duty to do so if they felt that their oath of office had been violated. They would have been under a constitutional duty by virtue of their position if they felt that there was an attempt to subvert their own oath of office. But here's another problem. There was specific evidence by Justice Jafta and Kabinde, and I would urge the court to look at the changes that were made by Justice Jafta and Justice Kabinde at the hearing of this application of this matter in December 2020. Sorry, there was a specific, very pointed changes to the statement of the Constitutional Court, which said Judge President Hlophe did not persuade us, not as a matter of consequence, but as a matter of action, He never told us where to go, who to decide in favor of. All he said was what is recorded there. This is an important matter. It touches on the issue of understand. It touches on the issue of legal privilege. And it must be important for you as the Constitutional Court now resolve a split judgment of the Supreme Court of Appeal of 3-2. And this issue has been in existence for a long time. And so now you really are involved in a situation where you have to have complete judicial consensus on that principle that has now been changed by a judgment of the Supreme Court of Appeal now in the Constitutional Court. So I'm saying to you, to Justice Sutherland, that on the facts of the case, properly looked at, it could never be suggested that this was a judge so lacking in judgment or so lacking in character. It has nothing to do with the character of the judge. These are friends who were engaged in a conversation, and this friend actually says to the justices who were hearing him, look, I dealt with this matter. There was a point where I felt uncomfortable, but look, I dealt with it. There was really nothing. And at critical moment, when he is about to be cross-examined, he says, no, let me change something that I think may well have influenced how others see this case. There was no attempt to persuade us or me in relation to the matter of Zuma. We're not told where to go. We're not told how to handle evidence. We're not told which way to go. The man expressed his views, just views. And this is another thing that I personally, as somebody who enjoys constitutional law, just cannot grasp. What is it about judges that their rights to hold and express views was difficult for the JSC to understand? They don't even explore that. They don't even go as far as saying, well, let's see whether we can find that this exercise of the right to hold a view and express it to a colleague on a pending matter is a right which should never be exercised. No attempt is made to actually just explore the right questions. What do judges say to each other when they're in the confidence of their own chambers? How far do they go? Who policies those conversations? And what is it that makes one gross judicial misconduct? And if this is the standard of gross judicial misconduct, no judge in South Africa is safe, because judges talk.
Mr. Masuku.
They talk amongst themselves.
Mr. Masuku, much as you've said that, you said Justice Jafta said he was not persuaded, or JP Hlophe did not try to persuade him, but he is the same judge who warned Judge Nkabinde, watch, this issue of Zuma may be raised. Doesn't this show that there was something untoward regarding the conduct of JP Hlophe? Why did he go forward and tell his colleague that to be very careful when you communicate or when you meet JP Hlophe?
Well, perhaps we develop that question further as I answer it. When Justice Nkabinde is warned, as your question posits, is warned that Judge Hlophe may discuss the case that is pending, Judge Nkabinde does nothing about it to prevent a violation of a own oath of office. Now, I'm walking backwards in answering that question, starting at how the judges themselves would have looked at the issue. It is clear that Judge Nkabinde, when he looked at what Judge Jafta said, he still applied the relevant attitude, presumption of judicial independence. And that conversation does not appear to have been a warning that something inappropriate was going to take place. Because if it had been a warning, you must then ask yourself, why did Justice Nkabinde provide a platform for an inappropriate conversation to take place if he had been warned?
Okay.
But going back to what Justice Jafta himself says, he says, well, you can call it a warning, but it's just a remark that was born out of the fact that Judge Nkabinde had said to him, Judge Hlophe said he was going to come and discuss a mandate, or privilege, the issue of privilege, right? And then in that context, then Judge Jafta says, oh, well, maybe he will speak about the Zuma case. But that did not raise warning bells. And a judicial officer who knows about an inappropriate conversation that is just about to take place has a duty to prevent that. If you hear that I'm coming to your chambers to do something inappropriate that violates the law, you do not allow me to even come into your chambers, because to do so would be to present, to create a difficulty for yourself. So you prevent it.
Okay.
And so that is.
I've noted what you said. I just want to indicate that you've been addressing us for almost 2 hours now.
Can I?
Sorry,
yes,
DJP, can I just round off that question? Are you saying, Mr. Masuku, that judges, it's a form of free speech with judges interacting with each other?
Yes, that's exactly what I'm saying. It's one that is captured in the Code of Conduct, Article 11. It's Article. Yes, Article 11, which specifically says, so Article 11 says a judge must, that's mandatory terms, serve in the discharge of judicial office, not comment publicly. And it doesn't add privately. It says not comment publicly on the merits of any pending case before or determined by that judge or any other court. And then it says in B, not enter into a public debate, and again public and no private debate about a case irrespective of criticism leveled against the judge. And then it says further, but there is one, Article 11.3 says formal deliberations as well as private consultations and debates amongst judges are and must remain confidential. And there's a reason why that is so, because judges are the only policers of these private conversations. And that's the space where judges can freely talk. And sometimes the conversation between judges may be uncomfortable. A judge says something that is inappropriate. The other one says, Mr. So-and-so, please, man, don't do that. It's inappropriate for you to say that. It's either racist or sexist, or it's bigoted, and it's just wrong. You don't say things like those. And that's the end of the matter. Sometimes judges in conversations amongst themselves disagree in a debate. But the fact that one judge in that disagreement feels uncomfortable about the conversation is no evidence that a presumption of integrity has been violated. There has to be more than just that. And in this case, I have said, Justice Victor, I've submitted that amongst judges, there has to be the primary starting point is that judges are also holders of the right of freedom of speech in Section 15 and 16 of the Constitution. And of course, it's got its own limitations as you go further. You then can engage in those limitations, which include a right, that right not exercised in a way that undermines judicial independence or that promotes the violation of an oath of office. And just so
Thank you, Mr. Mr.
Thank you, Judge Victor. Just so maybe a round of, I'm also sensitive to the time. We stand by our heads of arguments, every aspect of it. On the issue of the right remedy, there are many complications that we can see immediately. But we say to the extent that those complications exist, this court doesn't have to venture into them if it decides not to. It could simply set aside the findings of the JSC, and we say in the tribunal, and leave it there. The JSC has got its own processes that it must engage in. It must start the call meeting de novo and start afresh. And we will have, and perhaps just an aside, Judge President Ledwaba and Justices, I say an aside because this is an experience that is personal to me. I was 5 years at the bar when this matter started, 5 or 6 years. I'm now 19 years at the bar. It's still running. If you set this matter aside and you set aside the relief of the JSC findings, and it goes back to the JSC. There is no guarantee that the JSC will have the legal capacity to deal with it in a way that enjoys public confidence in the integrity of its own processes. It would violate Hlophe's right.
The JSC should be dissolved.
No. I mean,
No,
perhaps
at
it should.
Different times, JSCs, there are different people who are members of the JSC.
No, but that's the problem, Justice Ledor, because remember that when the case started, there was a group of JSC members. In 2009, they found that there was no evidence to convict Hlophe of gross judicial misconduct. Interlopers, and I call them interlopers because they have no constitutional status in the case. But they went and reviewed and set aside, except for the Premier of the Western Cape. They went and set aside the judgment of the JSC findings. And then we find on the same grounds in 2021 that the JSC has committed same legal errors. We're here before you saying to you, the JSC did not have the jurisdictional standing to make the finding that it did. Just on that only issue. And I'm not even saying go as far as I have argued, which is to say that they erred because they failed to apply the law that governs or that must govern an inquiry into a judge's probity or integrity, which test would arise in circumstances where and the SAFU and the other judgments tell us that when you are recusing a judge, the threshold is higher and you must be a reasonable person. And I've said what a reasonable person would say, hearing or seeing these two judges engaged in a private conversation. There is this JSC that would be dissolved, and another one comes up, and this new one may conduct a process in which they find that Judge President Hlophe has not committed any gross judicial misconduct. Where does it end? When do we protect judicial independence? Are we not exposing a judge who is a leader of a division to constant attacks that undermine the office of the judge? And I'm saying at some point it must stop. And at some point, the JSC ought to be told, you have so grossly undermined your constitutional obligations that this time you are a threat to judicial independence. You are a threat to the independence of the integrity of an office of a judge. You undermine the public's confidence in the integrity of the judicial office, in the manner in which you deal with these things. Today is Hlophe, yes, and people who don't like him will be happy that it's Hlophe. But tomorrow is Judge Ledwaba. The other day it's going to be Judge so-and-so. The other day is going to be Judge so-and-so. At some point, when the matter comes to the courts as custodians of judicial independence, they must apply the right test and tell the JSC what it is they must do in order to get this thing right. So we can say the JSC must be, and in fact, initially we'd say you must grant us a permanent stay on it. But I know that I can't get that kind of order to grant a permanent stay. But there are very compelling reasons why a declaratory order ought to be given, that the JSC has failed in relation to this case to perform its constitutional duties in terms of section 230, but the section of the Constitution I refer to in the papers. Justices, I have not addressed the issue in Part D, which deals with the order that we seek against Parliament. But simple, in 1 minute, the argument we make there is...
Before we go there, can we finish these arguments?
Yes.
I've got two questions for you, if I may.
Thank you, Judge.
Pardon me. If on the premise that you contend, it would be appropriate for us to declare that the Judicial Services Commission has been derelict in the manner in which it conducted its business, on what lawful foundation do you invite us to make the decision that it could have made rather than remit it, regardless of our criticisms?
No, remittal by a court requires that the JSC deals with the matter in accordance with its own processes. And we're not suggesting that even with the declaratory order, you ought not to remit in a way you are telling them that they ought to invoke the appropriate constitutional provisions to perform the responsibilities they ought to perform. But I am inviting the court to look beyond just what the JSC must do, but why it must do so.
You want us to give the JSC guidelines how to do its job properly? No.
Perhaps the guideline is to declare that they failed in their duty, and then they must conduct their hearings in accordance with the Constitution. That's essentially the guideline that they must get. But what we're asking you to look at is, in looking at their failure, look at what, for the 13 years, what that implies for judicial independence and the integrity of the judicial office. And ask yourselves, is it appropriate to subject a judge of a high court or any court to this kind of, and I would say, lawless conduct? Does it protect the judicial office, the integrity of the judicial office? Does it protect judicial independence? And that's why I'm saying, stripped of everything else, the conduct of the JSC in dealing with this matter, with the tribunal itself, where they see their role as vindication of another witness, is just so wrong that it ought not to be tolerated by any court, which is enjoined to affirm the importance of the status of the judge and the status of the court. And so I can't, by reference to a law, suggest to your lordships, sorry, to the court, I beg your pardon, Justice Victor, to the court, when the court says simply reviewed and set aside with the appropriate declaratory orders that we seek, the JSC must then invoke the correct processes. But I've already mentioned that if the JSC is invited to begin these processes again, they will take another 13 years. We will come back again. I'm sure most of you will probably be retired by then, but we will come back to your replacements, and we'll come and argue the same cases that we were arguing today.
Choose yourself.
Well, thank you for that. Can I put my second question to you?
Thank you, Judge.
I'm interested to examine carefully the substantive platform for the review. Can you perhaps summarize for us what you say the JSC did that was outside its lawful scope authority, and or what it did that was irrational, and or what it did that was unreasonable, that would have to appear in the judgment in order to uphold your contention?
Yes, thank you, Justice Sutherland. The first is that aside the jurisdictional issues, the JSC failed to apply the correct law. So they completely ignored the correct law. They spent time suggesting that the presumption that is extended to judges is in fact part of our law. And if one looks at what the judgments say that those presumptions derive from the Constitution itself. So would say that there was a failure on the JSC to apply the law as to resolve the issues. They failed to apply the correct test that must decide whether or not a judge's conduct has exceeded the protection offered by these presumptions. And then we would also submit that it's important. It's also just that the JSC condoned a procedural irregularity of the tribunal, which saw its duty as to vindicate the honor of witnesses and complainants in the matter, and that was not their job. That job was to investigate. It's statutory prescribed in Section 26 of the JSC Act. It was to investigate and to make appropriate recommendations, not to vindicate the honor of other people. So I would say the JSC failed at base to conduct a lawful process, because it did not, or to conduct a process that accords with their obligations under Section 177, 1A of the Constitution. And that the findings that they made were therefore irrational in relation to the purpose for which it is established. The findings, which are clearly inimical to the presumptions of judicial independence and the presumption of integrity, are equally, but those findings are inimical to the test that we proposed they should have been applied when dealing with whether or not those presumptions ought to be withdrawn from the Judge President Hlophe, and a finding of a gross judicial misconduct is appropriate. But can I just add one more last thing? The findings, the job of the Judicial Service Commission is to stand as guardians of constitutional, of the independence of the judicial appointment. They do that in the appointment of judges, which, as you know, has got its own controversies, and I make no submissions in that regard. They also stand guardians of judicial independence in their inquiry into the conduct of judges. So their primary aim is not to punish a judge. That is not their primary aim. Their primary aim is to ensure they make decisions that advance judicial independence. And if the removal of a judge advances judicial independence or advances the integrity of the judicial office, or upholds the public's confidence in the office of the judiciary and the office of a judge, then that is what the JSC ought to do. It's not a punitive issue. And here you will see that there was not even an attempt when they were dealing with aggravation, the so-called aggravation factors. No attempt to call on President Hlophe to say, President Hlophe, there are things you said about judges which we don't like. You've not specifically been charged with them, but we are minded to wander into that area and to explore whether or not we can't find that you were naughty when you went that far. No attempt to do it. No hearing given on those aspects. They simply spring them in a judgment as their own observations, which are based on their understanding of their role, vindication of the honor of justices of the court. But what would be very crisp, Justice Sutherland, that I wish to come out in the judgment is the test for judicial misconduct. That test, if they get it wrong, they will always get the outcome wrong, and they will always place judges in an unenviable position. Consequently, the judiciary and the public's confidence in that judiciary. The test was simply not applied as it would be applied elsewhere. And as I said, I invited the court to look at how the Canadians have dealt with it, where the Canadians look and say, is the conduct so destructive, and the Canadian so destructive of the concept of independence, impartiality, dignity, and all that, that a judge who is not removed would undermine the office of the judge going forward. It's a forward-looking exercise. Should we keep this judge? Because to keep him would undermine the integrity of the judiciary itself.
Thank you.
I'm not sure if I answered that question,
Yes.
Judge.
Mr. Masuku, can I ask you this in response to the first question by Deputy Judge President Sutherland on the question of remittal? If I understand the case, then you say there's really no power of delegation. The appointment of a acting Deputy Chief Justice or Deputy Justice is really only for the purposes of the Constitutional Court. I'm thinking of your response to 175. So can it ever be remitted? Because, you know, who is going to act for the President of the Supreme Court of Appeal if both the deputy and she is conflicted? So it seems as if remittal is not possible.
Yes,
Same problem.
Yes, Justice Victor, I think you put the thing on the pulse, because you see that is the reason why we tried to explore with the Constitutional Court the argument that there ought to be flexibility in how you interpret composition. But we are bound by that judgment, so we can't get out of it. But a remittal to the JSC I suppose the court must take the view that it is for the JSC to then decide how it executes its own responsibilities, and not to tell them who should be there and who should not be there. That's what the two judgments of the Supreme Court of Appeal have done. They still get it wrong, despite having been told. And perhaps this is a point where the judiciary ought to be saying, no. You are failing in your constitutional obligations. I can't really answer that question as crisply as I wish I could answer, but a remittal would create a new set of legal problems. And those problems, we tried to argue, Justice Victor, in the Concord. I think, I'm not sure whether you're there when we argue this case, but there's an argument we submitted before the Constitutional Court in the Hlophe case, where we said, on the doctrine of necessity, even if judges are conflicted, because they are the ultimate decision makers on the questions of constitutional meaning, they must nonetheless sit with their conflict, which is an administrative law.
That is provided that it's reasonable.
Yes, that is the proviso. Yes.
Yes.
But we say
your submissions depended on whether we accept the two cases that you've referred to.
Yes.
Whether we accept your application of those two cases.
That is correct.
But we can I'll put that to you in reply if necessary. Thank you, Mr. Masuku.
Thank you. Just as I say, I've not addressed other issues, but I stand with the heads of arguments. Can I then give my colleague Hlophe 15 minutes?
Yes.
I know 15 minutes is probably not his favorite number, but I think in the context of how far I've gone, you'll have to just live with it.
Okay. You may proceed.
Thank you, Judge.
Advocate, I think it's Sadiki, am I right?
Yes, Mr. Siddiqui.
It's Sidagi.
Sidaki, sorry.
Sidaki,
Sorry,
yes.
Sidaki. I've written Sidaki. I don't know why do I read it the other way around. It's Sidaki.
Yes, it's got a weird name, so it's my friend, but that's why I can say that.
Yes.
Thank you, Justices. To cut straight through the chase, I'm going to address the point. What is the value of the evidence given by Mr. Chilwane, the Secretary of the Judicial Services Commission? Given that he has not averred personal knowledge of the facts to which he has deposed, he has not averred or expressed a belief that the facts to which he has deposed are true and correct. He has not averred personal involvement in the taking of the respective impugned decisions of either the tribunal or the JSC. He has not averred that the facts in his affidavit were obtained in the ordinary course of his duties or records at his disposal, or that he has engaged the official records to gain insight to the facts to which he deposed. He has not averred that he's engaged with the record of proceedings in the tribunal, in the JSC, to appreciate the nuts and bolts, the significance of the decision-making or adjudicative processes of the tribunal and the JSC. Nor has he explained how he acquired knowledge of the facts. And these are facts spanning a long period of some 13 to 14 years that are under consideration in this matter. Now, in paragraph 152 of the JSC's heads of argument, the following submission is made from line 3. It says, however, it is apparent from the affidavit when Mr. Chilwane makes assertions based on information provided, documents that are in the Rule 53 record, when he makes assertions relying on information that President Maya, Deputy President Betse, and Mlambo JP gave to him, and when he makes assertions about issues relating to the processes of appointing acting Deputy Chief Justice, which engage his administrative function. We submit, my lords, my lady, that submission is problematic in many and various ways. For instance, Mr. Chilwane asserts in his affidavit that there was, firstly, the powers of the president of the SCA, President Maya, alternately Deputy President Betse, were delegated to Justice Mba. In their confirmatory affidavits, those justices do not confirm the alleged delegation or appointment. They merely confirm why they felt they could not attend the meeting of 25 August 2021. Now, we refer to, there are various other instances, and there are many of these instances in which Mr. Chilwane's affidavit, where the assertions made without providing the necessary supporting information or laying a basis for those assertions. Thus, the reliability and probative value of much of what is stated by Mr. Chilwane is left in question. In other instances, Mr. Chilwane merely makes assertions without explaining how he gained insight to information or how he arrives at certain conclusions. We refer to a sample of such assertions. At paragraph 11, Mr. Chilwane states, the tribunal acted within the ambit and scope of the terms of reference and afforded Hlophe JP a fair hearing. Mr. Chilwane, as we have demonstrated, his duties are those of someone who keeps records. How he can make an assertion of that nature is unclear. And the question is, how does Mr. Chilwane know and can make an assertion of this nature if he was not a member of the tribunal? In another instance at paragraph 13, he states, in what follows, among other issues, we show that Hlophe JP was afforded a fair hearing before the tribunal and the JSC. And he goes further as to what was, how that happened. However, Mr. Chilwane has not alleged that he studied any of the evidence before the tribunal or the JSC, and it is unknown how, as secretary under the provisions of the JSC Act, he formed his views on these matters. There are other instances, my lords, my lady, I can refer to. I'm unmindful of the time. They are all from paragraph 511 of our heads of argument. And we enumerate these instances. I'll just highlight some of them. So, for instance, at paragraph 201, Mr. Chilwane states, Chief Justice Mogoeng and Deputy Chief Justice Zondo were unavailable to attend and chair the meeting at which the JSC would consider the tribunal report. Mr. Chilwane does not say how he knows the Chief Justice and the Deputy Chief Justice were unavailable. And we state that this statement is in any event ignores the principle on this point, as was decided by the Constitutional Court in the matter of Hlophe versus FUL and Premier of the Western Cape. If I may just get the case. I beg your pardon, my lords, my lady. In moving, I've misplaced my papers. I refer to the matter. It's dealt with at length in our heads of argument. If I may refer to, in that matter, paragraph 30, where the constitutional...
Give me the citation before you go to the paragraph, please.
So it's a matter of FUL, sorry, of Judge President Hlophe versus Premier Western Cape.
Yes.
Judge President Hlophe versus Freedom Under Law. Its citation is 2012, volume 6, SA, page 13.
Yes. Yes, can refer us to the relevant paragraph.
Paragraph 30, I refer to the discussion really from paragraph 30 to paragraph 42. And in this discussion, the Constitutional Court was dealing with the issue of appointment of acting judges in relation to a conflict, that arisen in the Constitutional Court relating to certain of the justices, which meant that there couldn't be a quorum. Now, at paragraph 33, the Constitutional Court reasoned thus: it is by now settled that constitutional provisions must be interpreted according to their purpose, gleaned from the language read in the context of the Constitution as a whole. Language, context, and the scheme of the Constitution all show that ad hoc acting appointments to cater for exceptional cases like these confronting us here are not permissible. Paragraph 34, Section 1751 provides for the appointment of an acting judge of the Constitutional Court if there is a vacancy or if a judge is absent. It was not argued that the recusal from a particular case by a member of this court creates a vacancy under the section. but it was argued that the recusal does render the judge absent. The ordinary meaning of the word absent carries some ambiguity. It may mean merely physically absent. It could reasonably be argued that a recusal creates a physical absence for the purposes of a particular case. However, any possible ambiguity is removed when we consider that the recusal from a particular case does not preclude Constitutional Court judges from continuing to perform duties of their office. A recused judge remains required to perform the rest of her judicial duties. The action of recusal is the performance of a judicial duty. The effect of a recusal, therefore, cannot be considered to be an absence. I flag in this regard, my lords, my lady, the letter that was written by Acting Chief Justice Zondo to the Minister, supporting the appointment of Justice Kampempe, in which Justice Zondo stated that on that day of her appointment, he would not perform his duties. And I submit that entry in his letter is contrary to this judgment which he was part of. I go further to paragraph 41, where the Constitutional Court stated the textual interpretation dealt with above finds further support in the context of the Constitution as a whole. Constitutional provisions relating to the appointment of judges must be interpreted with due regard to the constitutional imperatives of separation of powers and entrenchment of judicial independence. The potential danger to judicial independence and the separation of powers is ever present in the appointment of individual judges to hear a specific case, and we must be mindful of this. I flag here, Justices, of course, the appointment of Justice Kampempe to hear a particular case, albeit not even in court, but in the JSC. We submit that appointment fell foul of this principle. I flag here further the involvement of the executive in the appointment of judges in this manner. And it rings true what the Constitutional Court cautions here when they say there's a potential danger to judicial independence and separation of powers. And we ask this court to consider that this must be a principle to be observed, not just for this matter, but for the future. It's important that the executive be mindful when making judicial appointments that you don't find a situation where there's a potential danger caused to judicial independence and separation of powers. At paragraph 42, the Constitutional Court concluded, accordingly, it is not possible to interpret absent in section 1751 as covering a situation where Constitutional Court judges recuse themselves from hearing a specific matter. We submit, my Lord, Justices, that that important principle is ignored by Mr. Chilwane when he says the Chief Justice Mogoeng and Deputy Chief Justice Zondo were unavailable. the chronology of events has been set out in Judge President Hlophe's supplementary affidavit of how Chief Justice Mogoeng went on leave. It is clear there that his leave was for a period of 3.5 months, which would have expired prior to the 25th of August. And therefore, when one considers the principle in this Constitutional Court judgment, it cannot be said that it cannot be said without more that Chief Justice Mogoeng was unavailable, or that Deputy Chief Justice Zondo was unavailable. In any event, Mr. Chilwane contradicts himself, having stated that Deputy Chief Justice Zondo had mandated Justice Khampepe to chair the JSC meeting on his behalf. In this instance, it seems to suggest a recusal of sorts. And of course, a recusal does not amount to unavailability in terms of the principle of as set out in the Constitutional Court judgment. This further contradicts the other assertion that Justice Khampepe had to chair the meeting because of a decision that had been taken that she was seized with the matter. We deal with this point of seized with the matter elsewhere in our heads of argument. I merely highlight that it cannot be said that Justice Khampepe could have been seized with the matter, because when one considers the principle that was established in the JASA judgment in relation to the appointment of an extension of the appointment of then Chief Justice Ngobo, the Constitutional Court was emphasized that when a body like the Constitutional Court, and we say similarly to the JSC, the chairperson does not have a special status separate when they sit en banc, does not have a separate status such that it could be said that the chairperson or the Chief Justice is seized with the matter, excluding the other persons who sit with the chair or the Chief Justice. So in this matter, it's important to note that Justice Khampepe was not the chairperson, similarly to a judge, where the other members of the JSC were sitting as parties presenting to her. So she couldn't be said to be seized with the matter as a chairperson. All the JSC commissioners were equally seized with the matter. However, the dynamic then arises where after that meeting, Commissioner Sikoko then passed away. He would have been seized with the matter on this understanding. Commissioner Tsepe recused herself. She would also have been seized with the matter. So those complications are there, and they're not dealt with by Mr. Chilwane. And we submit that it cannot be said that Justice Khampepe was seized with the matter. Yes, now, in answer to an invitation to provide a copy of the deliberations that had taken place between Deputy Chief Justice Zondo and Justice Khampepe concerning the JSC meeting, which was to deal with this matter, Mr. Chilwane responding by saying, well, any deliberations or discussions between Acting Chief Justice Zondo and Justice Khampepe were not part of the JSC's decision process when considering the tribunal report. Such discussions would accordingly not be part of the record of decision, as contemplated in Rule 53 of the Uniform Rules of Court. Firstly, we submit that those discussions would certainly have had to be part of the record. Secondly, Mr. Chilwane does not say how he knows such deliberations did not concern the relevant JSC meeting. Nor does he provide a basis for saying such discussion fell outside the purview of the Rule 53 record. In answer to a point made by the JSC, in answer to a point that the JSC had filed 2 contradictory and uncertified transcripts concerning the JSC.
How much time do you think you still need to finalize your submissions?
With your permission, Judge President, another 15 minutes?
Another 15 minutes. I think colleagues, you can assist me. It's now 1 o'clock. Should we proceed after lunch, or can we give him the opportunity?
I'm content to hear it.
I think we should hear it. Acting President.
Okay, proceed. I will give you another 10 to 15 minutes at most.
Thank you, Justice. Now, in answer to a point made by that the JSC had filed 2 contradictory and uncertified transcripts concerning the JSC meeting of 4 June 2021, Mr. Chilwane responded by saying, well, the first transcript was loaded erroneously on case lines as it was incomplete. That is why it was removed from case lines and replaced with the correct version. We submit Mr. Chilwane's answer raises many questions, but at the very least, it is wholly inadequate. It is not clear whether the error was made by Mr. Chilwane himself, perhaps in the course of executing his secretarial and administrative duties, or whether the error was made by someone else, or how exactly Mr. Chilwane came to know about this error. Mr. Chilwane does not say who made the changes to the transcripts, how those changes were effected, and why none of the transcripts bear a transcriber's certificate. And we submit that is only in relation to transcripts relating to relating to the meeting of 4 June 2021. We highlight that there is no transcript in relation to the meeting of the 25th of August 2021, nor is there an explanation. As relating to the attendance register for the JSC meeting of 25 August 21, Mr. Chilwane merely responded to say, Mr. Sikoko's name was included erroneously as he had passed on. There was no attendance register for the meeting of 25 August 2021 because there was only one commissioner from the list of commissioners who were part of the meeting of 4 June 2021 who was not part of the meeting, which was Commissioner Sikoko. Mr. Chilwane does not say who made this further error, how he came to know of this error. It's all silent. We make reference, Justices, to the case of von Obo versus Government of the Republic of South Africa, 2009 to SA 526. Where the court dealt with a situation where a senior state law advisor at the Department of Foreign Affairs had deposed to the opposing affidavit in a matter where the president and government ministers were respondents in an administrative law related review application. The applicant in that matter pointed out in the replying affidavit that the evidence of the state law advisor was inadmissible because it amounted to hearsay and did not reflect his personal knowledge. And citing a number of cases, the court held at paragraph 45 that Mr. Stiermet, the deponent, is a senior state law advisor. His evidence, unless confirmed by others who were privy to the meetings, the documents, advice, and or information on which he comments, is limited to his personal and or professional involvement therein. Paragraph 46, the courts have long and consistently held that it is impermissible for a deponent to an affidavit to give evidence on behalf of another where the latter does not file a confirmatory affidavit to confirm that evidence. Paragraph 48, in the light of this trite law, the effect of this failure by any of the respondents to adduce evidence is that the evidence in Stiermet's affidavit regarding what was in the mind of any of the respondents as justification for their decisions to refuse diplomatic protection is hearsay and inadmissible. The Constitutional Court in President of South Africa versus Safu, paragraph 105, accepted that hearsay evidence falls to be ignored even in the absence of an objection or an application to strike out. We make reference to another case, Drift Supersend versus Mogale City, local municipality. I'll just touch on another case, Shackleton Credit Management versus Microzone. It's also in our heads of argument. This was a matter in the context of a summary judgment application, a decision by Wallace J, as he then was, page 13 of that judgment, where the judge stated, it may be that the effect of such cases, as Van Heerden had said in Standard Bank versus Sekatsa Investments, that first-hand knowledge of every fact which goes to make up the applicant's cause of action is not required, and that where the applicant is a corporate entity, the deponent may well legitimately rely on records in the company's possession for their personal knowledge of at least certain of the relevant facts and the ability to swear positively to such facts. However, I do not understand any of the cases as going so far as to say that the deponent to an affidavit in support of an application for summary judgment can have no personal knowledge whatsoever of the facts giving rise to the claim and rely exclusively on the perusal of records and documents in order to verify the cause of action and the facts giving rise to it. Mr. Lombert's affidavit would have been more accurate if he had not claimed personal knowledge of the facts, but said that according to the documents obtained from Absa Bank, the claims in the present action are well-founded. The facts relied upon by him emerged solely from those documents. However, the moment that is recognized, it must also be recognized that the substantive contents of the affidavit consist entirely of hearsay. And we make further, we refer to other paragraphs, relevant paragraphs in that matter. I'll jump over, my lords, to the case of the Supreme Court of Appeal in President of RSA versus Mail and Guardian Media, Ltd. It's a 2011 for BCLR 363 SCA case. It's a matter relating to access to information relating to a refusal by the President to give requested information. At paragraph 37 of that judgment, the court stated, knowledge of the occurrence of an event might come to a person in one of three ways, it might come to him or her through directly experiencing the occurrence of the event, or the occurrence might be reported to him or her by someone else, or he or she might deduce that the event has occurred by inference from other facts. If knowledge of the occurrence of the event has come to a witness from direct observation, then his or her evidence is admissible to prove that it occurred. If that knowledge was acquired from someone else, then a proper basis must be laid for admitting it as hearsay and enabling its weight to be evaluated. And if the knowledge was acquired only by inference, then that is not evidential material at all. It is for a court to draw the inference itself upon proof of primary facts. Paragraph 38, a court is not bound to accept the ipsa dixit of a witness that his or her evidence is admissible, particularly in cases of this kind, in which information is within the peculiar knowledge of the public body. Proper grounds need to be demonstrated for the admissibility of the evidence. Merely to allege that that information is within the personal knowledge of a deponent is of little value without some indication, at least from the context, of how that knowledge was acquired, so as to establish that the information is admissible, and if it is hearsay, to enable its weight to be evaluated. In this case, there is no indication that the facts to which, in that case, Mr. Chikane purports to attest came to his knowledge directly, and no other basis for its admission has been laid. Indeed, the statement of Mr. Chikane that I have referred to is not evidence at all. It is no more than bold assertion. Paragraph 39, it was submitted by counsel that the appellant...
Paragraph, we'll read the paragraph, Mr. Sitake.
I refer to paragraphs 39 and 41, my lords,
Yes,
my lady. I'm aware that I've run out of time, my lady. I merely conclude by saying that in the absence and having been invited, the JSC was invited to respond to these issues, and they failed to do so, and they've provided no explanation. We submit that the court cannot give value to the evidence of Mr. Chilwane. Similarly, the evidence of Ms. The evidence of Ms. the deponent for the freedom under law, Ms. Fritz, must similarly be approached in a similar vein as to what is its probative value in the light of that she was not part of the administrative body that took the decisions. On that score, my lords, my ladies, my lady, those are our submissions. Thank you.
Okay. Thank you very much, Mr. Sitake. The court will adjourn. It's now 1:15, and we resume at 2 o'clock at 14 hours. Court adjourns.
Just sort it out. Just close it as in, yeah.
that if they try to stop the court from applying the law or doing so impartially without fear, favour or prejudice. And what does this mean? Its meaning was winkled out in the case of Beauregard, which has been quoted by my learned friends and kind of explains, after a fashion, what we're dealing with. It is to be found in Van Rooyen's case, among others, which is referred to, the references are in my learned friends' heads, and in the judgment of Chaskelson CJ in paragraph 19 of Van Rooyen's case, and there quoting Beauregard, the learned Chief Justice said, or quoted, historically the generally accepted core of the principle of judicial independence has been the complete liberty of individual judges to hear and decide the cases that have come before them. And then the parts that are being quoted all the time are: no outsider, be it government, pressure group, individual, or even another judge, should interfere in fact or attempt to interfere with the way in which the judge conducts his or her case and makes his or her decision. And that's a core principle of judicial independence. But what this also means is that if it is left, if a judge if it is left to the complete liberty of an individual judge to hear and decide the case, it's up to them how they will hear or decide the case. Then there's no interference with independence, because that is outside the prohibition which is expressed by this judgment. And we say, with reference, for example, to a statement made by Jafta AJ in his complaint statement, or made by Lange CJ, which was confirmed by Jafta AJ, that he said in his conversation, in no uncertain terms, to Hlophe JP, that the case of Zuma and Tint would be decided on the facts and on the law of the facts. And it is apparent from that he was left to decide on the facts and on the law, and I will deal with what the words that were said, but there was not, the judge was at liberty.
Just on that point, if it would be allowed that a judge could approach other judges where judgment has not yet been delivered to give the views, and at the end of the day, that judge gives judgment in favor of a person that was, let me rephrase it, just like in this case. If judgment was going to be given in favor of former President Zuma, won't this create a perception that there's interference in the judiciary?
That's exactly where I'm going to.
Okay.
Because we don't for a second suggest that a judge can approach another judge in another division and talk about a pending judgment, and certainly in a way that suggests an outcome. That's not what we suggest, or not what we're saying at all. We say that, and so for this we go back to another case, and that was the case of it's Generu, and it is quoted by my learned friends, and it appears it appears in paragraph 32 of the Van Rooyen case. And there, the Chief Justice says that in dealing with this, the High Court adopted the test in generu, which is whether the court or tribunal, from the objective standpoint of a reasonable and informed person, will be perceived as enjoying the essential conditions of independence. That the appearance or perception of independence plays an important role in evaluating whether courts are sufficiently independent cannot be doubted. The reasons for this are made clear by Canadian jurisprudence in Valenti, where De Dane J. held both independence and impartiality are fundamental not only to the capacity to do justice in a particular case, but also to individual and public confidence. So what is involved, without confidence, the system cannot command respect. It is not just it is not just then the interference with the independence, but it is the perception in the public mind of interference, which is the mischief we submit in this case, because we submit it doesn't reach the level of gross misconduct. The mischief was creating a public perceptions. I think the words used by Lange, by Chief Justice Lange, was threatening the integrity of the institution. But the fact is, that creates a perception, and that is why the judge can never ever approach another judge with his pending judgment and express these views. But that is the level, we say, of the mischief in this case. It doesn't reach the level, the plateau of gross misconduct, and on the facts, it doesn't reach the level of actually interfering with the independence, inter alia, because we draw that inference inter alia from the statement by Jeff de Jay, which I didn't quote. I'll give the reference. But the point we're making, that is the mischief that was committed and should have been dealt with, rather than trying to establish violations of section 165 sub 2 and 165 sub 3. Because we say that on the facts, Hlophe's words objectively left the judges at liberty to write their own judgments. And so the problem the mischief is one of perception. Now, the new charge that was raised, because after 12 years, the court will remember that the charge against Justice Hlophe was changed, and it was read out to Justice Jafta before he was cross-examined, and you'll find that at 008, pages 4296 and 7, and then, only then, was the charge pitched at a violation of section 165 sub 2 and 165 sub 3. An expression of attempts were used, attempt to interfere, and we say that as that was formulated, the charge at that stage, it was now a competent charge for impeachment. But we say that on the facts that plateau was not reached, and we emphasize the difference between interference, which is the word used in section 165(3), and which is a violation, and influence, which is what the JSC found. And practically and semantically.
May I just ask you this? On this continuum of perception that you describe, when is it misconduct? At what point on this continuum does it become gross misconduct? Our submission is that in these particular circumstances, my learned friend has said that if there's theft or if there's drunken driving or something, well, that's a crime. But on this continuum, it would have to reach the plateau of an identifiable charge, and the only identifiable charge is if it reaches gross misconduct, and it would reach that when there is an interference with the functioning of the court.
So if there is influence, you haven't reached that plateau. There must, what section 165 sub 3 makes clear is you interfere, that's the one word, with the functioning of the court.
And then public perception doesn't matter. It has to be active interference. So public perception then.
No.
Doesn't come into
No. We're saying that 1653 is the competent offence. That the plateau for interference in the functioning was never reached. But the mischief that did occur was involved public perception. It was the perception of independence which was affected, and that we say is misconduct, but it is not gross misconduct as contemplated by section 177. That's the submission.
Yes.
And we make the distinction practically and semantically between interference and influence, and we do that by reference to interesting findings that were made by the Mwepi Commission. And I know that the Mwepi Commission was tossed out, but no court has ever commented adversely on what was said there about the difference between interference and influence. And the court will find that in 008141 at paragraphs 31 and 32. I can just reach to my and that is 31, 32. Here we are. So there, what they said was the following. In the light...
Just bear with me a moment, Mr. Dunning. I just want to catch up with you. Paragraph 31, you said.
Sorry, no, it's paragraph 30. It's at 008140. It starts there and it goes on to the next page.
Starts the allegation that.
Sorry, no, it's I've got 008141. Sorry, 140 is where I have it, and there's a paragraph 30. I hope my numbering, because I couldn't access the case line, so I had to have it printed for me.
I'm afraid the pagination you have isn't in.
Yes, is it in the thousands or is it 140? 008140.
It's 008140, 140.
Oh, it doesn't come up.
Well, let's work on your paragraph.
Okay.
It's 30, 31, you mentioned.
30, starting with 30. If I may just read it.
Yeah.
What they're grappling there with is exactly this problem. In the light of the language used in the complaint, it's necessary to examine and to contrast the words improper influence and interference. The Constitution provides that no person or organ of state may interfere with the functioning of the courts.
That is not paragraph 30 on this page.
Yes, it's not. That's not my paragraph 30 either.
What is the document in which this reference is found?
Is it the founding affidavit?
It's state. Sorry, no, wait a minute. It's not. It's Yeah. The document is headed Judicial Service Commission, 28 August 2009, complaints of judges of the Constitutional Court, decision and reasons of Judicial Service Commission.
This is the 2009 Judicial Conduct Committee.
Judicial. Well, it was, as I understand it, this was the committee's. These were the committee's findings.
Judge Mwepi Mr.
Yes,
Semedia, and I
and the
forget
two
who else.
senior counsel. This was what was thrown out.
Well, I'm afraid I can't find what you're referring me to.
I think it must be in the thousands, 008 thousands up. I mean, the record starts at about page 3,000.
I'm going to have to ask my learned friend to try and find it on case lines. Right. But if I may just read it so as to make my point. Right. Because the point is simply that there is a material difference.
Can I assist with the reference?
Yes.
Can I assist with the reference?
Yes.
It's an attachment in the founding affidavit. And it's on page 001 112.
I'm afraid we may have to then give you a complete re-referencing.
You will see paragraph 32 there. That's where they discuss the influence and the others.
Yeah. Yes.
And now mine's upside down. So anyways, perhaps read it because mine's upside down.
So may I just read?
Yes, you can read it.
Thank you. The Constitution Court, in describing judicial independence, approved the dictum that the concept denotes complete liberty of individual judges to hear and decide cases that come before them. No outsider, be it government, pressure group, individual, or even another judge, should interfere, in fact, or attempt to interfere with the way in which a judge conducts his or her case and makes his or her decision. The meaning of the word interfere is also case and context specific. The concise Oxford Dictionary defines interfere to mean meddle with, intervene, take part in, combine in different phases so as to cause partial or complete neutralization. In contrast, the word influence is defined to mean action of a person or thing on or upon another, perceptible only in its effects, moral power over person, etc. The word interfere carries with it a meaning of conduct more serious than influence.
Mr. John, can I ask you then, is it a subjective assessment or objective, the distinction between influence and interference?
It's
I understand the dictionary meaning, but
it's a semantic difference. They mean different things, like murder and assault.
But then, is it in the eye of the judges?
So they both tested objectively, but they have different meaning.
Right. Okay.
If the word is used as interfere, it's not the word influence.
Isn't there a fundamental problem to, forgive me while I lost control of my computer, forgive me. It's very interesting that in 2009, three people got together and took the view that this was a useful analytical distinction to make. But ultimately, is not the question of what does or does not constitute gross misconduct in a given context a value judgment to be made by persons who are authorized by law to make such a distinction? And that's the JSC. What we know is that in 2021, they made a value judgment as to what constitutes gross misconduct. Isn't the question before us not all the possible permutations of how gross misconduct could be conceptualized, of which one is the thesis you're offering us now, but simply whether or not the choice made by this JSC is irrational? If it's not irrational, even if we prefer an alternative, then it's of no consequence.
Yes, but with respect, it is they have a discretion or a power. The power is vested in them. But when they apply the facts to the word misconduct, they must apply it, gross misconduct, they must apply it to the word gross misconduct, and we say to the word interference in section 1653, because there is no other rule. When you're looking at gross misconduct, the law says there must, or the law has always said, whenever the question is raised, what is the rule that was breached? And rationally, you have to look for a rule. And if you look for a rule, the only rule that relates to that particular situation directly is you may not interfere with the functioning of a court. That is direct.
Assuming that your proposition that 165 is the source of the rule and there is no other source, and that we look textually at 165. If the JSC, in its treatment of the matter, takes a wide view of those words and the phrase to encapsulate influence, then that destroys the distinction that you invite us to make. It comes down to a value judgment on how broadly 165 is to constitute the threshold, which may or may not, on these facts, a separate question, have been breached.
Since time immemorial, as I understand it, misconduct or misconduct, if it's judicially examined, would have to be tested against a standard. It could not be tested according to the discretion of the judge. There has to be a standard and a reference point. And the reference point has to be gross misconduct as contemplated in section 177. It can't be gross misconduct as contemplated by the members of the Judicial Service Commission, especially if the history of South Africa has, if there is a legal body of law on what gross misconduct is.
Well, we're not that far apart. My point simply is this, is with the concept of gross misconduct, as with many other concepts dealing with social dynamics, there is always going to be a range of plausible constructions. If the law vests an institution with the authority to determine what it consists of in a given context, then even if we as this court would have preferred an alternative, we cannot interfere with that unless you can demonstrate why its choice is irrational. And that's really what we need help with. Why is the JSC of 2021 guilty of an irrational formulation of the standard or threshold or test, whatever word you wish to use, of gross misconduct?
I would rhetorically ask the question, where in the law is there a rule dealing with a judge going to see another judge and influencing or affecting the judgment? And the answer to that, sorry, I'm interrupting, and the only answer to that, and the highest answer to that from the supreme law of the country is it is no person may interfere with the functioning of the court. That is the rule that is laid down by the Constitution when you deal with somebody interfering with the functioning of the courts. And
I'm with you on that. I'm taking that proposition that you advance as the platform. If the JSC, the authorized body takes a broad view of interfere, and in its judgment, the value judgment it makes, it embraces influence, then articulate for us how we formulate a judgment declaring that decision to be irrational.
Because if interference is the categoric imperative, they may embrace influence, but they can't make influence the test. And if we go and we look at their findings, they made influence the test. They set a charge sheet, which they read to Justice Jafta, which said you violated 162 and 163 by interfering. That's the charge.
Attempted to interfere.
You attempted to interfere, but when they made their final finding in the final paragraph of their ruling, they didn't reach that plateau. They said it was attempting to influence. When they knew and they laid out interference, they knew and laid out violation of 162 and 163, and they did not make a positive finding that there was a violation of 165 or whatever. Even if they'd said that, had they said, we find that you violated 165, 2 and 3 because you unduly or whatever, they would have reached a plateau. But they never. But their final judgment doesn't go to 165, 162, and it doesn't go to the word interference, which is the operative word used in the charge. So we say, for purposes of comparison, that there was a competent verdict must apply, and that was the one of misconduct and not gross misconduct. That's, I think, as far as I can take this.
Thank you.
Thank you.
Just on that aspect, Mr. Danon, you specifically use the word that the competent verdict should apply, but there was no charge of misconduct.
No, well, no, I'm sorry. Perhaps I shouldn't have used it. I used it as the Deputy Judge President said, very broadly and loosely. What it was is if it wasn't gross misconduct, it doesn't mean the applicant walks away. Within the act, misconduct still constitutes a mischief which requires their attention. That's what I mean.
Okay.
And in paragraph 32 of just to complete what I was saying, they say it's insightful that the word interfere, as opposed to influence, is used both in the Constitution and in the Code of Judicial Conduct. The premise, understandably, is that the function of lawyers and litigants is to influence judges to make findings in their clients or their favor, whereas there may be a debate about whether influencing a judge carries with it some turpitude. It's unquestionable that interfering or attempting to interfere with a judge in the conduct of his or her duties calls for censure, including in an appropriate case removal from office. And perhaps at this stage I should just turn to our heads of argument at 20, 21 and 26. We illustrate there why it's necessary that influence should not is completely different to interference, because influence can be good and it can be bad, and it's something that is done I would imagine in your ladyship's experience happen every day, where acting judges ask for opinions, ask for advice on tricky matters like shipping law and negotiable instruments, if those still exist, and they need that advice, and they take that advice, and that's influence. but it's not undue. So basically, we say, as Mr. Masuku, had the applicant offered the judges a bribe or threatened them or their families, their conduct would have posed a threat to those judges acting independently or without fear, favour or prejudice, or other than according to the dictates of the Constitution and the law. And the behaviour would then have been gross misconduct. But the applicant's behaviour did not go anywhere near that level or pose such threats. It caused no harm to the functioning of the Constitutional Court, nor did he ever suggest, and this is our real point, he never ever suggested, and I defy the respondents to find evidence to this effect, that the two judges should not make their own independent decisions, or that they should not apply the Constitution or the law, and in the absence of material evidence to such effect, or a specific law, regulation, or provision of a code that he violated, it cannot be said that he committed gross misconduct and should be dismissed. And insofar as he attempted to influence, his actus reus was expressing a view that the Supreme Court of Appeal was wrong, and he left it to the judges to decide what they would decide in their judgments. And I've already said that Jafta told Hlophe JP that Zuma Tint would be decided on the facts and the law, and Justice Nikabindi snapped when Hlophe JP raised the question of privilege. So on the facts, we submit it was left to the judges to decide what was going to be in their judgment, and so this did not reach the level of interference within the contemplation of Section 165 sub 3. And we point out, and I shan't delay on this point, that it took 12 years before eventually the complaint was identified as a violation of 1652 and 1653, and that was put to Jafta, Justice Jafta, before before his cross-examination started. So if one then goes and looks at the conclusion of the JSC, just bear with me. What did they conclude? And this, I probably have the wrong reference, so I just won't, I will read it out. Their conclusion is, for the reasons set out above, we find that Judge President Hlophe's conduct rendered him guilty of gross misconduct as envisaged in Section 177 sub 1a, in that he attempted to influence improperly Justices Nikabindi and Jafta to decide matters that were then pending before the Constitutional Court in favour of the particular litigants. It was not violation of 1652 or 3 or interference, an attempt to interfere.
Mr. Donan, perhaps this is a convenient time to put this question to you. I appreciate that you have not made a concession that Judge Hlophe committed any misconduct whatsoever. And to the extent that you've referred to a lesser charge that would not be impeachable, that's purely for the purposes of analysing your primary contention, which is gross misconduct is beyond a certain threshold which was never reached. But would it be rational to construe the common cause facts as constituting any form of misconduct, even if not gross?
Yes. If I haven't conceded it, that is the point I thought I made, and that is the mischief is to be identified. It is not the violation of those sections. It is creating the perception that the courts are not independent. And within the meaning of Devereux and those cases. Sorry.
All right. So the and once again, I don't want to attribute to you a concession that you would not have made. But the distinction I understand you asked us to endorse is this, that a rational assessment of the facts as known could rationally result in a conclusion that the conversation was ill-considered and therefore constitutes a form of misconduct. But in the absence of causing ill effects, which we know were not caused, it doesn't reach the threshold which you posit.
Yeah, that would be it, and I would just add another little bit, and that is he said that he did not like the SCA decision. He said that there should be another, it should be overturned, and he said, and he used those words as we're relying on you, or something like that.
Yes.
But he never ever said, and Jafta J said, I told him what is not happening, and that is independent. Well, the words he used were, we are deciding on the facts and the law, and that is a conclusion that we are acting independently, and therefore it never goes beyond misconduct. Because what he was attempting to do was the impossible. He was if he was attempting to influence the judges, he was attempting to influence two judges who were completely independent, fiercely independent, and were unaffectable, if there's such a word. And
no, I take your point on that, but let's just look at this. I'm trying to work through the conceptualization you're inviting us to endorse. The fact that a judge to whom an inappropriate remark was made is of such character and such good judgment that they recognize that this is something to rebuff can surely not be a relevant consideration into a determination of whether there was impropriety in the first place, nor can it contribute anything to determining what is a value judgment, the scale of seriousness of the impropriety.
The scale of seriousness of the impropriety must be answered by reference to what he actually said. And what?
That's correct. I think the thrust of my question was, it doesn't matter that the judges were of sufficient moral fibre not to be influenced. We know that, as a matter of fact, the judgment that was eventually given was not contaminated by any improprieties. So that's a matter of public record. So examining the conceptualization you invite us to endorse, I'm asking you whether you concede that their attitude to the overture doesn't make a contribution to the conceptualization.
Well, it does. Well, we would submit legally, because an attempt to commit the impossible is an attempt. An attempt is, and that's what it was. And an attempt is punished according to Snyman, and we've sent the references through. Is punished more leniently than the executed offence because of the retribution factor. But the test, to answer your Lordship's question directly, we must look at Justice Hlophe's statements, and there I would respectfully say that we should ask ourselves what it was that he didn't say. He is never alleged to have said that they were not at liberty to decide or should not follow the law. He never said that. He didn't say he said the SCA got it wrong, but you must get the law right. He didn't say.
Just on that, Mr. Donnan, sorry to interrupt your answer. To reach the interference threshold by saying that the SCA got it wrong, is that not an express form of interference? I'm just trying to say that one's got to look at the word interference within a particular context, and that is the context that we have to look at to see if the JSC was rational in its decision. So the context is, oh, but the SCA got it wrong. Is that mere influence, or has the interference threshold not been reached in this particular context?
That is mere, I would say, opinion, because as we know, the SCA, with all due respect, do get it wrong. I mean, I'm thinking of the case of Nkata, where the judgment of the SCA was so wrong that it was ignored for purposes of the Constitutional Court debate.
But Mr. Donnan, the Constitutional Court, somewhere it's got to be right.
So there's so that in itself is not wrong, and insofar as reaching the plateau of interference is concerned, he never said they're not at liberty to decide or should not follow the law. The high water mark is, he said, you are our last hope. And I would submit that when he says you are our last hope, he's expressly leaving it up to Justice Jafta. He's not saying, I want you to act under my direction or do the following. He's saying, this is my opinion. I would submit a summary of this is my opinion, and you're our last hope in getting it right. But he's not suggesting in any shape or form you mustn't obey the law, mustn't follow the law. That's what this section 165(2) says. You mustn't follow the Constitution. You mustn't act dependent on my opinion. You mustn't depend on my opinion.
Just to go back to those words, you are last hope. Does that not reach the threshold of attempted interference at the very least? You're saying to another judge, you are our last hope. In other words, please write in our favor. Find in our favor.
Yes, he says that his desire is that you should knock over the SCA judgment. But he's not saying, and this is the test, he's not threatening their independence, which is the test. He is not saying you can't decide for yourself whether you want to agree with me. You've got to agree with me. And if he doesn't reach that way, if he doesn't say you can't write your own judgment, you've got to write mine, do what I say. If he doesn't reach that, then he doesn't get to interference. Well, what he gets to is...
Can I pursue this on a slightly different tack? We're all familiar with the fact that different judges faced with the identical set of facts may totally bona fide give different weight to different nuances, and when the outcomes are knife edge, you can get two perfectly plausible and decent rationalizations for opposite conclusions. So that's just a fact of judicial life. So now the Judicial Service Commission have looked at facts, and they have concluded a particular scenario was proven. So let's look at all the facts that they took into account. They took into account the fact that Judge Hlophe approached these two judges one of whom was his friend and the other he knew very little about. He approached them successively after a period of about a month. In both cases, he raised the issue which was critical to the appeal. To his friend, he says, "You are our last hope." To the stranger who he has arranged to meet in order to discuss notionally a point of law, he talks about having a mandate. He talks about the members of the Constitutional Court needing to learn or understand our history, which is a highly loaded phrase about which we can extrapolate if needs be, but I think all South Africans understand what that means. He refers to his associations with ministers of state, and he says that the person who is the subject matter of the appeal is about to become extremely powerful, and certain people are going to lose their jobs. He says all of this to two very junior judges, he being, to put it mildly, a heavyweight within the judiciary. If the Judicial Service Commission, in the discharge of its functions, drawing on all of those facts, concludes that it was gross misconduct, on what basis do we reject their acceptance of those facts and the inference which they drew? That's what we need in order to upset this judgment. So help us articulate why it was irrational for them to accept those facts as being critical and to draw the inference that it constituted gross misconduct.
Because on those facts, the proper conclusion is misconduct. But to go to court, to reach a conclusion, it's an opinion of gross misconduct, they need more. And those weren't the only facts. The facts were deposed to by the only eyewitnesses. And perhaps I should proceed onto that as my next submission.
What's your next submission, Mr. Donnan? Before you go to Ken, I just want to add to what my brother has said. I think when J.P. Hlophe approached Justice Jafta, in his opening remarks, he said, "Has judgment been delivered in this matter?" You recall that? Doesn't this show that he could have had some knowledge that in discussing a matter wherein judgment has not been delivered is frowned at?
So sorry, could you repeat that? I didn't quite.
No, I'm saying when he approached, I think it's Justice Jafta. He asked him if judgment has been delivered in the matter, and he was told no. Now, by him asking that question, is this not an indication that he could have known that it is frowned at to discuss a matter with a judge wherein judgment is still pending? Or are you not making anything out of that?
No. Look, that could be, but I would. I'm not ducking the question, but the answer is, when the answer was we haven't given judgment, that's the more material situation, because then he should have known that he must be very careful how he speaks about it. I submit that, and I don't mean any disrespect to the two judges. I mean only respect to them. And I submit, and in fact I don't have to submit it. There's no doubt about it. They were two fiercely independent, competent judges of the Constitutional Court, and that means that they were blessed with the capacity to understand the facts of what was happening in front of them and to draw conclusions. And one can't throw the words they said out of the window and say rather let's concentrate on what Deputy J.P. Sutherland said, those facts. Let's talk about what they, as judges on the one side of the cutting edge, felt was happening. What do they say, and what was the high watermark?
So, Mr. Dunnan, then you distinguishing between a robust, experienced judge and a different test would be applied to someone who's less experienced. If a senior judge from another division comes and says, oh, the SEA got it wrong. Are you looking at the recipient of the conversation, or is there no distinction at all?
No, I'm not. I'm giving the impression that I'm distinguishing these kind of judges. I'm not doing that at all. I'm saying these were judges, and they were competent judges. They were not silly. They were adults. They had seen what happened. They described what happened. They gave their conclusions about what happened. And those must be accepted by a body like the Judicial Service Commission. And I'll come to exactly what they said and how they and what their conclusions. And one can't go and plonk in one's finding, in one's final conclusions as was done. All the other things they said without considering the material factors that two judges stated as fact and stated as conclusion. And perhaps I should move on to that. So there were two parts to it. And that I don't think I've seen anywhere. Because you will recall that before they started their evidence, their counsel, Advocate Norman, reformulated what they had said previously, because they wanted to leave no misconception before the court, before the JSC, before the tribunal, about what their evidence was and what their conclusions were. So what she said and what was said was that Jafta AJ had originally claimed, and I quote, in the course of their conversation, Hlophe JP sought improperly to persuade Jafta AJ to decide Zuma/Tint cases in a manner favorable to Mr. J.G. Zuma. And that was expressly withdrawn by counsel for Justice Jafta, and who said that this had to be amended to, and I quote, in the course of their conversation, Hlophe JP said that the case against Mr. J.G. Zuma should be looked at properly, or words of similar effect, and added the words, Sesi Tembele, Kinina, you are our last hope. And when he was cross-examined, Jafta expressly rejected the first version as not being a true reflection. And he said that he and Hlophe JP had discussed a wide range of issues. The majority of the conversation was not about the case. At the end of the conversation, he did not perceive the JP to have any intention to intervene with the Constitutional Court. Jafta AJ did not regard himself as a complainant. He rejected the proposition that Hlophe JP improperly persuaded him to decide matters in favor of Zuma. And at the end of the conversation, he did not perceive on the part of the JP an attempt to intervene with deliberations So the high water mark, we say, of his evidence against Hlophe JP is really when it came, there was a section of evidence where he pointed out that the first time he reached any conclusion of impropriety was when he heard that Justice Nkabindi was also going to talk to Hlophe JP. And the first time, and he expressly says this, Jeff AJ, first time he thought of making a complaint, entered his mind was on the 28th of May 2008, 2 months after the conversation, when he and Justice Nkabindi met the Chief Justice. And then after the court complaint, and this is in our heads, both judges recorded, we've not lodged a complaint, do not intend to lodge one, and we are not complainant judges. And they had informed the Chief Justice and Deputy Chief Justice they were not intending to lodge a complaint or make a statement. Now, with all due respect, with that kind of evidence, how do you, as a Judicial Service Commission, not only reach a contrary decision, but reach a contrary decision that it was not only what Jeff AJ said was wrong, but that the misconduct, which could be construed, reached the level of gross misconduct. And our submission is plainly, if you look at that, it doesn't depend on their impermeability to and their own independence and the rebuffing. It arises from the fact that what their evidence was. So
it's now almost quarter past. How much more time do you need to up for your argument?
I hope I could
ask you some questions. How much more time do you need?
I hope I could do it in 15 minutes. I might need half an hour there, but I can do it quickly. I mean, I'll try to go faster.
Maybe also, as you'll be wrapping up, just assist me on this. Can we, in our judgment, say the JSC was wrong in finding that there was gross misconduct? It's just an ordinary misconduct. Is it not a task that should be dealt with by the JSC, not us? And if we make such a task, are we not in a way imposing on them?
I would say the finding is it was irrational, certainly on the basis of Justice Jafta's evidence, to go beyond misconduct and to the level of gross misconduct.
Yes.
And therefore the finding of gross misconduct is irrational. And the declaratory order that it was not misconduct as the applicant wants should be granted. The decision should be reviewed and set aside, and then should be referred back to be dealt with on the basis that there was misconduct less than gross misconduct. That's
okay.
May I have my 15 minutes today?
Yes, you can have your 15 minutes.
Thank you. So as I've said, Jafta confirmed on oath to Langa Chief CJ that he told Hlophe JD in no uncertain terms that Zumaton cases would be properly decided, its facts and application of the law to them. The difficulty evidence-wise, I would concede, comes from from Justice Nkabindi, because she gives an opinion. She too waters down her statement, her original statement, and I fear that my reference would be wrong, but I could quote what she says, and we could send you a note to the court giving the correct reference. My reference is 00843551. In the watering down of her initial statement, she said that paragraph 49 was to replace the inaccuracy in paragraph 10C, which suggests that what we conveyed to counsel was that Hlophe JP sought improperly to persuade me. That is incorrect. He did not seek improperly to persuade me. In my sense, he was attempting to influence me. So that's the high watermark. He was attempting to influence me, but he was not improperly trying to persuade me. And then she adds, which is more damaging, I might have said JP Hlophe was clearly influencing. This will be inconsistent with my evidence and also with the charge. It should read was attempting to influence. So that was her position.
I don't see DJP Sutherland. Is he
I'm worried about that, acting JP. He disappeared about 5 minutes ago, came back and disappeared again. The line is not stable at court. I think we better wait.
Dear Honourable Judges, Judge Sutherland is experiencing technical challenges with the network at the Johannesburg High Court. Apologies on that regard.
Okay. So maybe we'll have to adjourn for a moment and see how can we solve this problem. Okay. Yeah, let's adjourn for about 3 minutes to check how can we resolve this.
Sutherland, before your line got interrupted, was that the high water mark of the case against Justice J.P. Hlophe, it comes from Justice Nkabindi. But she too watered down her statement before she was cross-examined. And she said in her evidence that to Miss Norman, when Miss Norman was examining her, that a draft had been prepared, and paragraph 10C suggests that what we conveyed to counsel was that Hlophe JP sought improperly to persuade me. That is incorrect. He did not seek to improperly persuade me. In my sense, it was attempting to influence.
Apologies, counsel. The DJP Sutherland is struggling again. The network seems to be overloaded, so it's gone down again. He's trying to log back onto the proceedings.
What do we do? How do we go forward?
Maybe if, but it would have to be someone sitting next to Judge Sutherland. Is to do it by telephone, is to switch on the speaker, and then he will hear, we won't see him, he will hear us and he'll be able to speak. If I dial his number and then he'll speak through my phone. That's what we've done in the past when we have these problems. There's a general message to all the judges that there's a problem with the network.
Okay. Judge Victor, maybe can you contact him and then advise him how to do that? Because my aim was that at least we should finish the argument now and give Advocate Batlenda an opportunity today before we adjourn till tomorrow.
May I continue then?
Just one moment.
Just a minute.
I'm just getting JP Sutherland. DJP Sutherland is not answering the phone. I think he's battling to get back on and ignoring his phone. Hang on, here he is. Here he is.
Okay.
Can the parties hear acting JP? Can you hear Judge Sutherland? Just speak, Judge Sutherland.
Yes, can I be heard?
Can you hear?
Can you hear? Can he hear us?
Can you hear us? I mean, I mustn't speak.
Can you hear us?
I'm going to join on a different link.
No, I cannot hear him.
The High Court. Obviously, there must be the internet connection in the city.
Yes.
Oh, what a curse!
Because I see the Justice Judiciary emails are down. It reflects on my screen that they're down.
I suspect that the server's the source of the problem, but I'm now I'm using a different, I'm going outside, I'm using my own internet access. I'll have to carry on with this.
Yes, I can hear you.
Yes, we can hear you, DJP Sutherland. We can hear you, so you keep talking.
Very well. Right. If I can be heard, well, that's very nice. I'm not sure if I can hear anybody else. Let's try that.
Well, perhaps.
Can you hear me, DJP?
Just barely. I can just hear you. Let's try that because I'm clearly not getting a signal at all. I suspect there's a city-bound problem here. Let's pursue it as best we can.
Okay.
Right. So
perhaps if Mr. Donan can speak, let me see if I can hear what he's got to say.
Over to you, Mr. Donan.
So
keep talking.
Before the adjournment, I was dealing with I was moving to the evidence of Justice Nikabindi.
Yes.
Can you hear me?
Yeah, let's pursue it on this basis.
Right. Mr. Donan, DJP Sutherland can hear you, so please continue.
Let's proceed.
Thank you. And what I was saying is that Justice Nikabindi, just like Justice Jafta, before she gave evidence before the tribunal, the evidence on which the JSC would have had to base its decision, she watered down her previous statement. And what she said was, when she was being led by her counsel, Ms. Norman, was that previously in her statement, she had suggested, it was suggested that what we conveyed was that JP Hlophe sought improperly to persuade me. That is incorrect. He did not seek to improperly persuade me. in my sense, he was attempting to influence me. And then she says, a little later, I might have said J.P. Hlophe was clearly influencing. This will be inconsistent with my evidence and also with the charge. That should read, was attempting to influence. And then when she looked at...
Some terrible feedback now.
I think it's because two devices, maybe his device is starting to work. So I've switched off my device.
Can I
continue, Advocate Dana?
So then when she gave her she says she knew that Hlophe JP was coming to see her. She had been warned by Jafta AJ that he might discuss privilege in the case. And she says, now when he came to me, when we met, he had mentioned the issue of privilege. I did not make much of it at that time. I was cautioned, if one may use that word, whether warned or cautioned. But I became aware that he had discussed this matter with Judge Jafta, and when he started discussing the matter, regard being had that I had been one of the scribes who was allocated to write about this very issue of professional privilege, I snapped and I told him, you cannot do this, you're not entitled to do this, you're not a member of the court, you have no say in the case. And the judge president at that time said, my sister, I did not mean to interfere with your work. So that is the evidence and the high water mark of the conclusion. And we submit that it has to rationally present a case of attempting to influence, but it never gets to the threshold of attempting to interfere.
Mr. Donnan, can I ask you this? Is it not an aggravating factor that he selected Justice Nkabindi to have the discussion with someone? Or was it just fortuitous that they'd been at a meeting and he happened to select her to have this discussion?
It's not an aggravating factor, but I would certainly have to concede that it's a suspicious factor. That someone drew the conclusion that it was suspicious, then I would have a hard time arguing with them. But it was not aggravating, because he had his own reasons for, he says, for going to see her. He'd met her, he told her he'd see her, he was there. So
suspicion would be
yes, yes. So the upshot was, and this was in the Chief Justice's complaint, that both of the judges viewed the approach as improper. They rejected the approach, but they did not feel it was necessary to lodge a complaint. And then they testify that, in fact, when they met with the Deputy Chief Justice and the Chief Justice, they had taken a different view, because in the view of Nkabindi, and I think it was Justice Mahora as well, expressed the view that it's affecting. It does affect the court, this conversation. So the upshot is that the conclusion that we draw is that when you look at the Common Cause facts, which are set out in the JSE report, then we say, as said in Van Rooyen, there's a perception of independence being affected, and that perception is material to public confidence in administration of justice, and that is the true mischief, which was neither expressly charged nor expressly amplified before the JSC, but on the facts. The fact for misconduct, but not gross misconduct or interfering with the functioning of the court, of the judiciary, and we say this because you can't simply ignore the facts, the facts pointing the opposite way, and the opinions and the attitudes of Justice Nikabindi and Jafta AJ. You can't wish them away. Had there been a rule, like there eventually became a rule, that when judges are having these conversations, they shouldn't be used to influence the other judge. You recall in the rules there's such a provision, I think it's Article 11 in the notes. Had that rule been around at the time, things might have been different. But within the context of the rules that were around, and they came directly from the Constitution, the plateau, the jurisdictional requirement of gross misconduct was not reached to kickstart Section 177. There is just one last point I must just deal with. That's on the law. That was the case of freedom under law against the acting chair of the JSC. Paragraph 50 of that judgment is relied on, and seems to be relied on by the judges, counsel for the judges and counsel for the JSC, to suggest, well, this matters basically has been decided, and this court is bound by that court, by that decision. But that's not what the ratio. Sorry, it's not what the ratio does.
Sorry, maybe that's just.
I'll send it to my private address, so I'll send it.
Somebody who's
Ms. Callaghan, you're on speaker.
Excuse me, Judge.
You're on speaker. Is Judge Sutherland with you?
No, I'm not. This is just a.
But we can hear you. We can hear you, DJP. So maybe you should just stay at that point.
Yes, I know. That's fine. Ms. Tulloch's muted herself now. Right, carry on. Let's carry on.
Okay.
So our submission is that this court can't go as far as the counsel for the judges and JSC say, because the decision the judgment of the court in the freedom under law case was to set aside the JSC decision, and as a result, a new investigation by the JSC took place, and constitutional powers are vested in the JSC to decide whether Hlophe JP is guilty of gross misconduct, and the SCA cannot usurp those powers. And to the extent that it did, because it would appear from the reasons for upholding the judges, upholding the tribunal's findings, that the JSC seemed to be acting under the direction of that court, and that they merely seemed to be approaching the matter as one where where the matter was sent back to tweak the evidence with a little bit of cross-examination. But if that was so, then they were acting under the direction of an outsider, and that we would submit was unlawful. It was not competent to treat the fresh investigation as simply a tweaking of what went before, including cross-examination. And then most importantly, you can't simply say that court decided the facts, because as I pointed out, the facts as they existed when the freedom under law matter arose were altered by the two eyewitnesses, and their allegations were watered down, and they attenuated their evidence. And Jafta had told the JP in no uncertain terms that he'd be acting on the facts, and Justice Nikabindi testified as I said. So you can't just pretend that the facts that were before the Freedom Under Law case were before the JSC when they took their decision, and we submit therefore that this court is open to make a finding about rationality and gross misconduct and on the facts. And those are our submissions. Unless you think of something else. And I'm grateful and thank you for your patience.
Okay.
Because I must have exceeded my time.
Yeah, well, there were some interferences, but I think you're still within the 15 minutes. Thank you very much, Advocate Donen. It's now almost 20 to 4. And I'm proposing that we shall hear the argument of Advocate Batlender on Wednesday, because he said he's not available tomorrow. But there are some interferences, and then maybe it would be ideal if we adjourn now.
As you please, Deputy Judge President.
Yeah. You said you'd need about 30 minutes or so, but
no more than 30 minutes, yes.
Yeah. Colleagues, you happy that we adjourn?
I'm
and then
happy with that.
we'll excuse Advocate Batlender for tomorrow, and then we'll hear your arguments on Wednesday.
Thank you very much for accommodating me, judges.
Okay. Thank you, court adjourns, and we'll resume tomorrow at 10 o'clock.
Thank you. Thank you.
Thank you, Judge.
Thank you, Judge.